Bryan, Butler, Carter, Kaufman, Chazanall, Chisholm, DeBar, Delano, England, Fillingame, Frazier, Harkins, Hill, Hobson, Horn, Jackson of 11th, Jackson of 32nd, Johnson, Jordan, Kirby, McCall, McDaniel, McLendon, McMahon, Michelle, Moran, Norwood, Parker, Parks, Pope, Seymour, Simmons of the 12th, Simmons of the 13th, Sojourner, Sparks, Suber, Tate, Thomas, Thompson, Turner, Ford, Whaley, Wiggins, Williams, Witherspoon, Younger. Mr. President, a quorum, Mr. President.
Thank you. Would everyone please rise for the invocation given by Senator Whaley, followed by the Pledge of Allegiance by Senator Tate. Senator Whaley.
Thank you, Mr. President. This prayer comes from a constituent of mine, Reverend Keith Keaton of Senatobia United Methodist Church. So if you would, please bow with me. Most gracious and merciful Lord, I implore your presence and guidance today in the most crucial work that those in leadership undertake. Help them to understand the weight of their decisions and the ways in which their actions affect their fellow citizens. Assist them as you assist all of us in thinking of others above ourselves. Help them to have the love and compassion for all of whom they represent. We come to you acknowledging our limitations and our frailty. We are not always who we aspire to be. Our best aspirations are so limited when compared to your great desire for our lives. For our limitedness, we repent and ask for your forgiveness. Give us your grace to be the best parts of ourselves in everything we say and do this day. Send your Spirit to do more in us, in our community, than we can do ourselves. Transform our actions through the renewal of our hearts and our minds. Lord, we ask you to send your blessing into the work of this governing body, and that they may be a beacon of hope and love and joy and peace. In their work, may we bless others. Finally, Lord, where they disagree with one another, let them still be able to discover each other's value and humanity. Let them treat each other with dignity, for each person is a child of yours and bears your image, Lord. Without your help, all of their work and all of our work is in vain. Guide us this day in everything we do, and say, in the name of Jesus Christ we pray, amen.
Amen.
Please join me in the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, gentlemen. Thank you. Good job. That's very nice. Tell you, preacher. Good job. Now the reading of the journal. Senator Blackwell, you're recognized.
Thank you, Mr. President. I move to dispense with the reading of the journal.
Senator moves to dispense with the reading of the journal. All in favor signify by saying aye.
Aye.
All opposed, no. The ayes have it. Message and petitions, Mr. Clerk.
Mr. President, there are none.
Committee reports. Senator Blackwell, you're recognized.
Thank you, Mr. President. I move to dispense with the reading of the committee reports.
Senator moves to dispense with the reading of committee reports. All in favor signify by saying aye.
Aye.
All opposed, no. The ayes have it. Next, the reading of titles, bills, and resolutions. Recognize Senator Blackwell.
Thank you, Mr. President. I move to dispense with the reading of the titles of the bills and resolutions.
Senator moves to dispense with the reading of the titles of bills and resolutions. All in favor signify by saying aye.
Aye.
All opposed, no. The ayes have it. Introductions. Any introductions? Introductions. Seeing none, we'll move to the calendar. We'll move to the calendar. Senator Hobson. Senator Hobson, you're recognized.
Thank you, Mr. President. I ask that we go to item 1 on today's calendar and have the title read.
Mr. Clerk, please read the title.
Senate Bill number 2725, State Budget, bring forward certain provisions and transfer funds.
Make the usual motion.
Senator makes the usual motion. All those in favor signify by saying aye.
Aye.
All opposed, no. The ayes have it. Please proceed, Senator.
Thank you, Mr. President. Senate Bill brings all the code sections forward that we would need to set up the budget for this year. Section 1 through 5 deal with the 2% set aside language. Within that, Section 3 deals with the what we call the rainy day fund, working cash stabilization fund. Section 6 actually amends prior language that would have put money into the emergency orphan well, plug in the orphan well funds, but we've set that aside into a special fund now, so that's not needed. And Section 7 is the transfer section that we utilize for the general fund and the budget contingency fund, and transferring the funds from the capital expense funds to set up our budget. That's an explanation of the bill. I'll be happy to yield to questions.
Any questions on the bill? Questions on the bill? Questions on the bill? Seeing none, Senator, we're ready.
Move adoption by use of the morning roll call.
Senator moves adoption, use of the morning roll call. Does anyone object to the procedure? You wish to be recorded voting no. Present. Seeing none, morning roll call will reflect all said aye, and the bill passed. Senator Hobson, you're recognized.
Mr. President, I ask that we skip down to, I'm looking for today, I've got the wrong day's calendar here. We're skipped down to Senate Bill 2834. I'm not sure what number, I think
It's
it might be
number six
on
yeah,
the calendar.
It's number 6, Senator.
Thank you. I ask that we go to number 6 and have the title read.
Number 6, Mr. Clerk, please read the title.
Senate Bill number 2834, Mississippi Historic Site Preservation Fund Grant Program established within Department of Archives and History.
Make the usual motion.
Senator makes the usual motion. All those in favor signify by saying aye.
Aye.
All opposed, no. The ayes have it. Please proceed, Senator.
Thank you, Mr. President. This is a bill that I filed this year after 2 different incidents or events that came to my attention in the off-season, one of which primarily dealt with Native American sites. The other one deals with Civil War battlefields and civil rights sites that we have in our state. A lot of those sites have gone either have not received the attention that they deserve for preservation. And we've had occasions where outside groups have been interested in investing money in the state, but they want to see that the state has made a commitment or a match of some sort. This would set up a fund with the Department of Archives and History. I have not put a dollar figure on this, but I'm thinking somewhere in the neighborhood of $500,000 to $1 million to put in there as seed money for Archives and History to use as match funds for grants that would go to these 3 sites. Again, Native American, Civil War battlefield, and civil rights sites. And just a few high points in the bill. Eligible cost would include improvements to the land, permanent protective interest, conservation easements, cost of appraisals, environmental reports, surveys, title search, title insurance, and other closing costs as it relates to preserving these historic sites in our state. Again, the money will be set up at the Department of Archives and History. It would require dollar-for-dollar matching funds. There is a priority list in here about what items would be given priority. And that's generally an explanation of the bill, but I'll be happy to yield to specific questions if any members have any at this time.
Any questions on the bill?
If not, I move adoption by use of the morning roll call.
Seeing none, Senator moves adoption by use of the morning roll call. Does anyone object to the procedure? Anyone wish to be recorded as voting no? Present. Seeing none, let the record reflect all ayes by use of the morning roll call. The bill is passed. Senator Hobson, you're recognized.
I'll pass on the other items on the appropriations calendar and ask that they retain their place.
Items 2, 3, 4, 5, and 7 will retain their place on the calendar, on the appropriations calendar, and we'll move to finance. Senator Blunt, for what purpose do you seek recognition?
For an introduction, Mr. President.
Please proceed.
Thank you, Mr. President. It's my pleasure today to introduce my friend and constituent as our doctor of the day. Dr. Edith Rayford is in the North Gallery. She's standing now. She is a physician, member of State Medical, an OBGYN doctor here in Central Mississippi. She lives in Terry and is serving us today as our doctor of the day. We're glad to have you, Dr. Rayford. Thank you.
Thank you. Thank you very much, Doctor. Appreciate your help. Senator Butler, for what purpose you seek recognition?
Thank you, Mr. President. Mr. President, I would like to ask for unanimous consent to be added as a co-author of Senate Bill 2834.
2834. Seeing no objection, you're added. Okay. Senator Johnson, you're recognized on finance. We're on Bill 8.
Thank you, Mr. President. I'd like to go to item number 9 and ask that the title be read.
Item 8 retains its place on the calendar. Item 9, please read the title, Mr. Clerk.
Senate Bill number 2477, Mississippi Home Corporation, remove, revert on statute granting authority to issue negotiable bonds and notes.
I'd like to make the usual motions.
Senator makes the usual motion. All in favor signify by saying aye. All opposed, no. The ayes have it. Please proceed.
Thank you, Mr. President. This is a bill to delete the reverter for the Mississippi Home Corporation. This allows them to generate bonds that they then use to make home loans pursuant to several federal and some state programs. They currently have, the reverter was originally in there based on some federal regulations and time repeal dates with federal law, and it is no longer needed, and so this simply just removes that reverter. And that's an explanation of the bill.
Questions on the bill? Questions on the bill? Seeing none, Senator, we're ready for your motion.
Move passage by use of the morning roll call.
Senator moves passage by use of the morning roll call. Does anyone object to the procedure? Anyone wish to be recorded as voting no? No. Any present? Seeing none, bill is passed by use of the morning roll call. Senator, you're recognized.
Thank you, Mr. President. I'd like to go to item number 10, Senate Bill 2728, and ask that the title be read.
Mr. Clerk, please read the title.
Senate Bill number 2728, Department of Revenue, and retiring law enforcement officers to keep one issued sidearm each.
And make the usual motions.
Senator makes the usual motion. All in favor signify by saying aye. All opposed, no. The ayes have it. Please proceed, Senator.
Thank you. This bill allows for Department of Revenue retiring law enforcement officers to keep one sidearm that the state has issued to them. This brings them in line with law enforcement officers from MDOT, Highway Patrol, Bureau of Narcotics, and Wildlife, Fisheries, and Parks, and that's an explanation of the bill.
Any questions on the bill? Ready for your motion, Senator.
Move passage by use of the morning roll call.
Senator moves passage by use of the morning roll call. Anyone object to the procedure? Anyone wish to be recorded as voting no? No. Present. Seeing none, use of the morning roll call is granted and the bill is passed.
I'd like to go to item number 13, Senate Bill 2832, and ask that the title be read.
Items 11 and 12 retain their place on the calendar. Item 13, Mr. Clerk, please read the title.
Senate Bill number 2832, upholstered household furniture manufacturing job tax credit, extend repealer from 2022 to 2026.
Ask that we make the usual motions.
Senator makes the usual motion. All in favor signify by saying aye. All opposed, no. The ayes have it. Please proceed, Senator.
Thank you. This bill does exactly what the short title says. It extends the repeal date for 4 years from January 1st, 2022 to January 1st, 2026. And that's an explanation of the bill.
Any questions on the bill? Questions on the bill?
Move passage by use of the morning roll call.
One moment, please. Senator Blunt, you're recognized for a question.
Thank you, Mr. President. Thank you, Senator Johnson. This is on 2832, am I right?
Yes, sir.
Do we have any data to indicate whether this incentive program is a net positive to the state and the cost to the state of the program and the jobs that are created as a result of the incentive?
Would you repeat that? I'm sorry, I didn't know.
Do we have any data to indicate that this program is in the best interest of the state?
No, I asked for specific data on how many employees this affects, how many people are using it. I was told that it is below the threshold for disclosure, which I believe means fewer than 3 or 3 or fewer.
I'm having a hard time hearing.
I asked for some specific data about companies that do this or number of employees. I was told that it is below the disclosure amount, apparently, of 3 or fewer. So it's a small number of taxpayers this affects. I don't have that data to answer your question. I did request some data.
Well, and I'm not picking on this particular credit, but my frustration is with all these incentive programs we have, it seems to me it ought to be a pretty simple exercise for the state to say, okay, what's the cost to the state of this incentive and what is the net benefit to the state or the net loss to the state, and we ought to apply that scrutiny to all these things. And so as this moves through the process, we need, if there are barriers to us receiving the information we need to determine whether this is a net positive or a net negative to the state, let's do something to remove those barriers so we can have some information to decide if this is a good deal or not.
Well, as you know, and we discussed in a meeting the other day, I am all for getting good and accurate data.
Yeah, all right. Thank you, Senator Johnson.
If there are no other questions, move passage by use of the morning roll call.
Senator McMahon, you're recognized for what purpose?
Friendly question.
We yield for a question, Senator.
Yes, sir.
Please proceed, Senator McMahon.
Chairman, thank you for your work on this. You know, Northeast Mississippi is the upholstery furniture capital of the United States, and there are 45,000 jobs that depend on this type of legislation. And so I want to thank you for your work, and I know you're aware of how many jobs that could be affected by that. Is that correct?
Well, again, I did not get that total number of jobs, but if it's 45,000, then 45,000.
I appreciate your work on this. Thank you so much.
Thank you.
Thank you, Senator McMahon. Senator Norwood,
Thank you, Mr. President. A question.
will you yield for a
Mr.
question?
Chairman.
He's to your right, Senator Johnson. He's on in
Yes,
the
sir.
balcony there.
And welcome
You-
back, Senator Norwood.
Thanks so very much. Could you tell me the location of these manufacturers?
Again, they didn't give me the specifics because apparently it does not meet threshold for disclosure, being 3 or fewer, but I believe most of them, if not all, are in Northeast Mississippi.
Okay, and will we be able to access that data before we vote?
Would you allow me to work on getting that information for you? $1,000 tax credit for every person I employ. Currently, we have this before us, and it is to repeal it, to extend the repeal date. I would ask this body, let's extend this repeal date since it's before us now, to not put anybody in a bind that currently is counting on this, and then research it and bring it up next year if that's something that we should do.
Thank you, Mr. Chairman. Thank you, Mr. President.
Thank you, Senator. Any other questions? Any other questions? All right, Senator, we're ready for a motion, please.
Move passage by use of the morning roll call.
Senator, move a passage by use of the morning roll calls. Anyone object to the procedure? Does anyone wish to be recorded as voting no? Any no? Present? Seeing none, use of the morning roll call is granted. The bill is passed. Back to you, Senator Johnson.
I'd like to go to the next item, item number 14, Senate Bill 2850, and ask that the title be read.
Mr. Clerk, please read the title.
Senate Bill number 2850, certificate of title, allow application without usual documents for vehicle.
All in favor signify by saying aye. All opposed, no. The ayes have it. Please proceed.
Please recognize Senator Parks to explain this bill.
Senator Parks, you're recognized.
Thank you, Mr. President, Mr. Chairman. What this bill does, it creates a path for an owner of a car that is 30 years or older to submit an application for a certificate of ownership. Currently today, Alabama and Tennessee has this ability. As a matter of fact, this bill is modeled after Tennessee, but I'm happy to answer any questions that you might have. If none, ask for passage of the morning roll call.
We have one question, please, Senator. Senator Moran, for what purpose do you seek recognition?
Question, please.
Will you yield, madam?
I do.
Please proceed.
Quick question. I can see a potential double-edged sword on this thing. Being an old car, antique car collector and have owned many, let's say a 1970 Chevelle, I understand that when I had mine, I had a title. And I understand, let's say that your dad or your uncle or somebody passes away and you find that in the garage or in the shed was a 1955 Ford truck. But no one seems to know where the paperwork is. I understand being able to go down and do the affidavit and say, okay, I own this car, and they get the electronic title or whatever it is. But my concern is, what if you have one stored somewhere? Someone gets in there, gets the vehicle, you don't know it's gone, they go get a title, go down and get a tag, say that they own it, and there's no longer a title to the car if we pass this. Then you get in the debacle, does Mr. Smith own it or does Mr. Jones own it? Maybe you can help me clarify that, please.
Well, number one, we did not issue tags until 1969 in the state of Mississippi. But there is also a process on the application where you would have to define each piece of that car. And as the Department of Revenue does their research, just like they do today on any car, they run those VIN numbers to see where that belonged, where it was previously. Today, even if on a lost title, the same process you would go through that same process. So I think if you look at the records today at the Department of Revenue, we're not in the habit of relinquishing that ownership without due process.
So would it be a process where you'd either have to have a bill of sale and/or some documents showing that it was in an estate, that your family member or something?
It's a very lengthy application that they have to fill out before they can get that. And it's looked to see if there's any liens, there's anything against that.
You know, and
But this is what this is for,
Yeah.
is for you all that own these antique cars. From my understanding, and that's the reason that, that I'm doing it, is because you're looking for the ability or a process to move through to be able to do that so that you can show some validity as you are. And a lot of times we have these cars that they're piecemeal together,
absolutely. And
so each one of those will be on the record.
I guess my concern, being someone who unfortunately had an antique car stolen years ago and never laid eyes on it again, that's my only concern. I do understand the benefit of it. I just was with a little concern that if someone took it and you didn't know it for a month or two, and next thing you know, they have paperwork on it.
I totally understand your concerns. I've discussed this with DOR. They do not have any concerns. They would follow their current process that they do today, and this is Tennessee law.
Okay, thank you.
Thank you, Senator. Other questions on the bill? Other questions? Seeing none, Senator, we're ready for your motion.
Passage on the morning roll call.
Senator moves to passage on the morning roll call. Does anyone object to the procedure? Anyone wish to be recorded as voting no? No. Present? Seeing none, use of the morning roll call is granted. All will be recorded as voting aye, and the bill is passed. Senator Johnson, we're back on the calendar.
Thank you, Mr. President. I'd like to go to item number 16, Senate Bill 2816, and ask that the title be read.
Item 15 retains its place on the calendar. Item 16, Mr. Clerk, please read the title.
Senate Bill number 2816, public officials and employees allow Department of Revenue appraisers to receive same pay increases as county tax assessors.
Make the usual motions.
Senator makes the usual motion. All in favor signify by saying aye. All opposed, no. The ayes have it. Senator Johnson, you're recognized.
Yes, sir. So this, again, does exactly what the short title says. Currently, Department of Revenue appraisers have the same role as many county appraisers. The county appraisers can take certain classes, get certain certificates, and have a pay increase that is disproportionate to what the Department of Revenue appraisers are allowed to get. This bill would simply say that those appraisers can get the same pay increase for the certifications that the county appraisers get. And that's an explanation of the bill.
Any questions on the bill? Any questions? Seeing none, Senator, we're ready for motion.
Move passage by use of the morning roll call.
Senator moves passage by use of the morning roll call. Anyone object to the procedure? Anyone wish to be recorded as voting no? Present. Seeing none, the bill is passed by use of the morning roll call. Senator, you're recognized.
Thank you, Mr. President. I'd like to go to the next item on the calendar, item number 17, Senate Bill 2828, and ask that the title be read.
Mr. Clerk, please read the title.
Senate Bill number 2828, Alcoholic Beverage Control Division, remove provision that agents and inspectors do not have general police powers.
Make the usual motions.
Senator makes the usual motion. All those in favor signify by saying aye. All opposed, no. The ayes have it. Senator Johnson, you're recognized.
Thank you, Mr. President. This bill removes one sentence from the end of Code Section 67-131 that says, nothing herein shall be construed as granting agents and inspectors of the Alcohol Beverage Control Division of the State Tax Commission general police powers. I've tried to find out why that was originally put in there. I have not found the answer to that yet, but it is a Justice Court judge in Oktibbeha County decided that that was in contradiction to what their role is and threw out a case in which the officer pulled over some people who were using a fake ID. And so the department requests that we remove that so that they can make arrests or make traffic stops when necessary in performing their duties. And that's an explanation of the bill.
Okay, any questions on the bill? Questions on the bill? Seeing none, ready for your motion, Senator.
Move passage by use of the morning roll call.
Pardon me? I'm sorry, I see one. Senator Hill, one moment, Senator. Senator Hill, for what purpose you seek recognition?
Question, please.
Be you for a question, Senator.
Yes, sir.
Please proceed, Senator.
I'm not real familiar with the, how the agents for the DOR are trained. Right now, are they academy-trained police officers?
Yes, they are. And if you look at the beginning of that code section, it says that all agents and inspectors appointed under this chapter will receive a certificate of appointment under a seal of department. Let's see. That such agents and inspectors are hereby declared to be police officers in enforcing the provisions of this chapter. Now, as far as their training, as I understand it, they are trained as law enforcement officers to have this role.
Okay, thank you.
Any other questions? Any other questions? Now we're ready for your motion, Senator.
Move passage by use of the morning roll call.
Senator moves passage by use of the morning roll call. Anyone object to the procedure? Wish to be, of course, voted no. No, Senator Simmons. Anyone else? Anyone else? Seeing none, that's Derek. Please note Senator Derek Simmons voted no. Otherwise, the bill passed by use of the morning roll call. Senator, you're recognized.
Thank you, Mr. President. I'd like to go to the next item on the calendar, item number 18, Senate Bill 2830, and ask that the title be read.
Title be read. Senator, Mr. Clerk, please read the.
Senate Bill number 2830, new markets tax credit, extend MDA's ability to allocate by 1 year.
Make the usual motions.
Senator makes the usual motion. All in favor signify by saying aye. All opposed, no. The ayes have it. Please proceed, Senator.
This is for the new markets tax credit. This is only to extend it for 1 more year. That's an explanation of the bill.
1 year extension. Any questions on the bill? Questions on the bill? Seeing none, we're ready for your motion, Senator.
Move final passage by use of the morning roll call.
Moves passed by use of the morning roll call. Anyone object to the procedure? Wish to be recorded as voting no. No. Present. Seeing none, the bill is passed by use of the morning roll call. Senator, you're recognized.
Thank you, Mr. President. I'd like to skip down to item number 25, Senate Bill 2807. And ask
Items 20, 21, 22, 23, 24 retain their place on the calendar. We move to item 25.
Ask that the title be read.
Mr. Clerk, please read the title.
Senate Bill number 2807, alcoholic beverages, restore provision restricting areas in which manufacture, sale, and distribution are authorized.
Make the usual motion.
Senator makes the usual motion. All those in favor signify by saying aye. All opposed, no. The ayes have it. Please proceed, Senator.
Mr. President, this one is a committee sub. I'd like to move that we adopt the committee sub in lieu of the original bill.
You're recognized to explain the committee sub.
This particular provision, last year when we made possession, we eliminated the possession rules statewide so that you could have possession of alcohol statewide. Another sentence was also deleted, which allowed for some people to open up stores, package stores, and areas that are technically dry. So it did a little bit more than just the possession, and this adds that language back and has a grandfather clause for the ones that were opened. I think there was a total of 3, and then it eliminates the future opening of those based on the date of passage.
The date of passage. Any other explanation?
No, sir, that's it.
All right. Senator Hill, for what purpose you seek recognition?
I hate to ask you a question, Chris, but I can barely hear you because you're so tall and you're so far away from that microphone. Can you just kind of go back over that one more time? We're going back to the bill where we decriminalize possession.
Yes, ma'am. So we decriminalized possession statewide. In doing that, we also deleted language that prevented people from opening package stores in some areas that aren't truly wet for sales, manufacturing sales of alcohol. And so this would put that language back in so that it's okay to possess alcohol anywhere. However, you can only sell in areas that are approved to do so. And then it also protects the people who opened up stores under this language in the past year.
So people did open up stores?
My understanding, there were 3 stores that were open under this in areas that otherwise they would not have been able to.
Because after we passed that last year, I had our lawyers up here look at it, and they said, as far as they could tell, we didn't decriminalize anything except possession. And I couldn't find anywhere we did either. So whatever we need to do to fix it, I'm fine with it. Thank you.
Thank you. If there are no other questions, move passage by use of morning roll
We
call.
have other questions. 1 second. Senator Chastanall, you're recognized for what purpose?
Just for a question, if I may.
Yes, you're a U.S. Senator.
Yes.
Please proceed.
Thank you, Senator Johnson. All right, I believe I carried the bill last year that decriminalized the possession of alcohol, even in states where the sale of it is not permitted. Now, you're telling me that some people actually set up shop and started selling beer and wine and distilled spirits in counties where it was not permitted?
That was my understanding.
Say that again, I can't hear you.
That's the way I understand it. Yes, ma'am.
And the ABC allowed this?
Well, I believe
We already have one from England on this.
1 moment, please.
so. ABC was following what we did.
ABC did what, sir?
ABC was following what we did.
You'll have to say that again, I cannot hear you.
Yes, ma'am. ABC followed the rules that we set, followed the code as we set it.
So you're saying it was the bill that was flawed, not the behavior of the people that set up retail shops in dry counties?
I'm not saying that the bill was flawed, but it did allow for that.
Okay. Well, thank you for correcting this.
Thank you, Senator. Senator Hill, for what purpose do you seek recognition?
Just one more question, please.
One more question, Senator. Will you yield, Senator?
Yes.
Please.
I'm looking at the language on lines, the new section 26 through 38, and it says, it's basically, looks to me like it's saying that the municipalities can sell. Is there any qualification that those municipalities would have to voted wet, or is this extending to all municipalities?
No, I believe it's limited to those that have voted to be wet and qualified resort areas. And I think what we did when we took out some of this language, it made it where it could be set up in the entire county and not just in those areas.
I'm not seeing anything in here that talks about municipalities that have voted wet. Maybe council can answer that, because if we did something wrong last year, I want to make sure we don't do the same thing again. Because it says whether or not issued to permittees in such municipalities, qualified resort areas, or clubs.
So in 1087, which was the House bill last year that did this, it said, we deleted code section, part of the code section that read, except as otherwise provided in section, for holders of, and I apologize, this is a strike through, a caterer's permit, the manufacture, sale, and distribution of alcohol beverage shall not be permissible or lawful in counties except in incorporated municipalities within such entities, qualified resort areas, such counties approved as such by the State Tax Commission, or clubs within such counties, whether within a municipality or not.
Okay.
Thank you.
One moment. Okay, Senator Jackson. Senator Jackson passes. Okay, other questions on the bill? Other questions on the bill?
Mr. President, I'd like to just note that we always have laughs over pulling out the stool for Senators Polk and Sparks, but this is not friendly for tall people either.
All right, Senator. We're ready for your motion.
Move passage by use of the morning roll call.
We have to adopt a substitute first. So it'll be moved
Move
passage.
adoption of the committee sub.
All those in favor signify by saying aye. All opposed, no. The ayes have it. We're ready on the bill.
Move passage by use of the morning roll call.
Senator, passage by use of the morning roll call. Does anyone object to the procedure? Anyone wish to be recorded as voting no? No. Is there someone behind me voting no? Norwood.
Yes, sir.
Frazier.
And Frazier.
Norwood and Frazier. Anyone else? Anyone else? Seeing, pardon me? Sampson, Jackson, you're no, sir? Present, I'm sorry. Sampson, Jackson, Senator Jackson is present. Anyone else? Anyone else? Seeing none, the bill passed by use of the morning roll call.
I'd like to skip the remaining items on the finance calendar and ask that they retain their place on the calendar.
Items 26, 27, 28, 29, 30, and 31 will retain their place on the calendar. And we go to Chairman DeBar. Chairman DeBar.
Thank you, Mr. President. I'd like to call up item number 33 and have the title read.
Items 33. Mr. Clerk, please read the title.
Senate Bill number 2267, teacher license allow reciprocity if teacher possesses standard license from other state and passes background check.
Make the usual motions.
Senator makes the usual motion. All in favor signify by saying aye. All opposed, no. The ayes have it. Please proceed, Senator.
Move for adoption of the committee sub in lieu of the original bill.
You're recognized to explain the committee sub.
Mr. President, I ask that you recognize Senator Hill to explain the bill.
Senator Hill, you're recognized.
Thank you, Mr. Chairman, Mr. President. What this bill does, it basically says that anybody that has a standard license in another state and moves to Mississippi to teach will have their license processed in Mississippi based on their reciprocity from another state. We've had a lot of problems with teachers moving here and not being able to get licensed. And so with the teacher shortage that we have, this came unanimously out of committee, and that's basically what the bill does, and it will help us get teachers in the classroom faster. If they've been teaching and are in good standing in another state, there's really no reason not to license them if they've been licensed in that subject in another state. And we do have one amendment to clean up something in this bill. There's some lines on 387 through 391 that we need to delete about a background check because the department does not do the background check. The school that hires the employee does the background check. And the other thing on the amendment that we need to do on line 384 is to change the word 30 to 14 because we believe that with all the paperwork that's necessary once the department has it, that 2 weeks is sufficient to process the license.
Okay, first, we're still on the committee substitute, Senator Hill,
Yes.
so we'll answer questions on the committee substitute.
Any questions on the committee sub?
Questions on the committee sub? Seeing none, we're ready to adopt the committee substitute.
Like to adopt the committee sub in lieu of the original bill. I think the chairman already did that, but have to offer the amendment before I can ask for passage of the committee sub.
No, it goes the other way, Senator. We have to adopt the committee sub, then we'll offer the amendment. All those in favor of the committee substitute, please signify by saying aye. All opposed, no. The ayes have it. Senator Hill, we're on your amendment, please, ma'am.
Thank you. What the amendment does is amend lines 387 through 391 by deleting the background check through the department since that's done by the hiring entity, by the school in another code section. That was just an oversight when we drafted the bill. And on line 384, we would like to change 30 to 14, and that's after all paperwork is to the department that they would have 14 days to process the application.
Okay, questions on the amendment? Questions on the amendment? Seeing none, we're ready for your motion, Senator.
My motion is to pass the amendment.
Senator moves to adopt the amendment. All in favor signify by saying aye. All opposed, no. The ayes have it. We're back on the bill.
Thank you. If there are no more questions, I'd ask for passage of this bill on the morning roll call.
Senators ask for passage of the bill on morning roll call. Anyone object to the procedure? Anyone wish to be recorded as voting no? No. Present. Seeing none, the bill passes by use of the morning roll call. Senator Barr, you're recognized to continue on the calendar.
Thank you, Mr. President. I'd like to skip item 34 and have it retain its place on the calendar.
One moment, please. Senator Simmons. Senator Simmons, for what purpose?
Just for permission to be added as co-author, Mr. President.
Co-author on 33. Co-author on Senate Bill 2267. Is that correct, Senator?
That's correct, Mr. President.
Okay, other co-authors. Other co-authors. Let's go the other way. Is anyone who does not want to be a co-author? Anyone who does not want to be a co-author? Seeing no objections, granted. Please show all members of the Senate as co-authors on Senate Bill 2267. Okay. Senator Moran. Senator Moran,
That was my
that's
question.
co-author. That's very good. Senator Hill?
That was co-author.
Co-author. We're all good to go. 34 is retains its place on the calendar. Thank you, Senator Barr. Senator Wiggins, you're recognized on number 35, 2263.
Thank you, Mr. President. Go to item 35, call that up, ask the title be read.
Mr. Clerk, please read the title.
Senate Bill number 2263, cemeteries and burial grounds make misleading filings unlawful.
Make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye.
Aye.
All opposed, no. The ayes have it. Please proceed, Senator.
Thank you, Mr. President. This is a bill requested by the Secretary of State. As you know, the Secretary of State has jurisdiction over perpetual cemeteries and registration of cemeteries. And it's a simple bill, just says that if there's any misleading statements in their filings, that they would suffer a penalty. And that actually in Section 3 to rename it the cemetery law. So we're trying to get some of these things squared away. And with that, Mr. President, I do have a technical amendment to present at the desk.
Okay. Wait, just 1 second.
Council just had asked if we could do this technical amendment, changing the word chapter to article. So if not any questions, asked to adopt the amendment on the morning roll call.
That's just a yes, no, Senator. So all in favor of the amendment, please signify by saying aye.
Thank you.
All opposed, no. The ayes have it. Senator, we're back on your bill.
Thank you. And if there's any questions, be happy to answer those. That's the explanation of the bill with that one technical change. If no questions, my motion would be to adopt passage on the morning roll call.
One moment. We have another amendment, Senator. 1 second. Senator McMahon, you're recognized on amendment. Mr. Clerk, is the amendment up? Amendment's on the screen.
Thank you. I discussed this with the author of the bill. He knew I was going to bring this forward. Basically, this will just create another section within this bill, and it says within 30 days of determination that a false filing has been made, at the request of a person that's been falsely accused, that it'll be released to them who made the complaint. That's all it is. Be happy to take any questions. If not, move by passage of the amendment by the morning roll call.
It's just a motion. Senator, 1 second. Let's see. Are there any questions on the amendment? It's on the screen. Any questions? Would you like to speak on the amendment, Senator Wiggins?
Yes, Mr. President. I'd ask you to vote against the amendment. Don't know anything about this. It also, I think, based on the explanation, changes the purpose of the bill that was requested by the Secretary of State. This is a simple bill to just address these limited cases. So I would ask you to vote against the amendment.
Senator England, for what purpose do you seek recognition?
I have a question on the amendment.
To which senator, please?
To Senator McMahon.
Senator, you yield for a question.
I do.
Please proceed.
Yeah, Senator McMahon, we discussed this earlier. I just wanted to ask you a question that was relayed to me by the Secretary of State's office concern that they had over this particular amendment. The concern was whether this amendment would lead to situations where someone may decide not to file out of concern of being retaliated against or retribution of any kind. And they were concerned that this amendment could lead them to not get reports that would help them undertake this portion of their duties as Secretary of State and under that office. Just wanted to see if you had any, if you shared their concerns or if you wanted to address that concern.
Sure, I'll be happy to. You know, the Sixth Amendment of the United States Constitution says that you have a right to face your accuser. And, you know, funerals are a very difficult time for families. And I've got a funeral home in my area that someone keeps making complaints against this funeral home, and every time they're found innocent of the charges. It's happened over and over. And so all they're asking is they want to know what the complaint is so that they can try to address it. And that's what this bill does. It just says that if a family or someone lodges a complaint against this business, which happens to be a funeral home, and then they're found that they were falsely accused, that there's no problem, that they have a right to know who accused them. And even if they don't release the name, they can at least release what the complaint is so that they have an opportunity to make the adjustments to try to make it better for the public. I ask you to support this amendment. As I've stated, the Sixth Amendment of the United States Constitution says you have a right to face your accusers.
Senator Hill, for what purpose do you seek recognition?
Question for Senator McMahon.
Senator McMahon, will you yield for a question?
I do.
Senator Hill, please proceed.
Senator McMahon, we have this same problem with people calling in false allegations of child abuse and neglect, don't we?
Yes, ma'am.
And I don't know if you're aware, but many disgruntled family members will call that hotline and complain and make false allegations to stir up trouble, correct?
That's right. You know, family relationships sometimes can be very difficult, especially when families are going through breakups. And sometimes that's being used as a weapon to hurt the other person, and it's false allegations. And I think they have a right. That's not what this deals with, but I understand what you're saying.
It's a parallel, isn't it?
Yes, ma'am. It's the exact same thing.
And the Constitution's supposed to, I agree with you, give us a right to face our accuser, especially, you know, to defend ourselves. But in some instances where we have in the law, there's no opportunity for anyone to defend themselves because they don't even know who's charging them with what. Somebody just shows up at their door, correct?
That's correct.
I'm going to support you on your amendment because I think that there's other areas of the law that we need to address, and we cannot keep using this excuse that, well, if we tell who's doing all the malicious reporting, then an honest person won't report. Well, but people go to justice court every day and file affidavits if they feel like it's serious enough, don't they? And they sign their name, don't they?
Yes, ma'am.
So, but yet somebody can show up at my house and try to take my child or file a complaint against my business, and I will never know who's trying to maliciously malign me, correct?
That's correct.
Thank you.
And look, let me share. I didn't discuss this with the chairman. This came up this morning. I discussed it with Senator England, who's the author of the bill. He knew I was going to make it. I thought he was going to carry it on the floor. And, you know, I appreciate Chairman Wiggins, what he's doing, and I would be willing to lay this bill on the table subject to call, and we could discuss this further. But if we're going to vote on the amendment, I would ask you to support it. You have a right to face your accuser when you're found innocent time and time again. I ask you to support the bill, or support the amendment. Thank you.
Recognized.
Thank you. I have a question for Senator McMahon.
I yield.
Please proceed.
Senator McMahon, these filings, are they public filings if someone makes a complaint against a cemetery, or do these just go to the Secretary of State and then they investigate?
They are public filings, but they are not subject to release because of this code section. Currently, this code section, 756371, they do not have to release the information. Imagine for a moment you being a businessman. You're an attorney, you own a law firm, that someone makes allegations against you at the bar multiple times, and there's investigations, and each and every time you're found innocent, but yet you don't know who keeps making the complaint. Wouldn't you want to know at least what the complaint is, even if you don't have the person's name?
Are the allegations that are made at the bar, do those provide you with the name? In other words, an example you just have given me, do you know whether an attorney could go find the name of the individual?
I do not know that answer. I'm trying to give you an example. What's before us is individuals have a right, when the Secretary of State's office, when they've been reported false allegations, that's what's before us. They just want to know what the complaint is so they can try to address it to make their business better, or just try to address it so they don't have to constantly go through the gyration of the same investigation, and they don't even know what they're being investigated for. That's what this does.
Yeah, thank you, Senator Mann. I would just to follow up on my question, I would say that I have constituents, and we're taking up a lot of legislation this year dealing with cemeteries, and a lot of my constituents are individuals who have loved ones that have been buried, and they have issues with individual funeral homes or cemetery owners, and I told them when I came up here I'd be glad to help them try to rectify the situations that they're undertaking. This is a very, very tough time in their lives, and I just would hate to think that we're doing something that's going to keep them from reporting to the Secretary of State. I would point out that nobody's children are being taken. What's happening here is that you're reporting an individual that may conduct a funeral service for you or conduct a burial. And those people, I think, should be able to go to the Secretary of State's office and be able to report these things without fear of retribution. Would you agree with that?
Yes, I do. And if the funeral home is found guilty of the charges, then the name's not released. This is if the funeral home or cemetery is found, there's no malpractice, there's nothing guilty. We talked about this, Senator England, at length, and I think, I thought you were going to carry this bill on the floor. You thought that as well, and we discussed it, and I think you thought this was a friendly amendment. Don't you agree?
All right, other questions? Senator Hobson, you're recognized for what purpose?
Question, Mr. President.
Please, question. Will you yield, Senator?
I'm afraid to, but I will.
Thank you,
Senator
Mr.
Hobson,
President.
please proceed.
Okay, thank you, Mr. President. Senator, I'm confused about one aspect. I've got confusion about the bill, and then I got confusion about your amendment. And I'll keep this to your amendment. This takes effect July 1, 2021 in the bill, correct?
It does.
And your bill states that it's within 30 days of the determination of the false filing.
That's
you can
correct.
go through this procedure, but then it says it shall be retroactive. How is that going to work?
That would apply to any past filings where people have been falsely accused. If they were found innocent, that they would release what the complaint is.
So if the law at the current time is that it's not going to be released, you're saying that they ought to be able to come back and file a suit or make a claim, find out who their accuser is?
Correct. Not a suit, just find out who their accuser, or at least what the complaint was.
Does that violate any ex post facto provisions of the law?
I don't know if it does or not.
Come on now, you knew the Sixth Amendment pretty well. You don't know about ex post facto?
I said I was afraid to answer the questions because apparently you have me at an intellectual disadvantage, Senator.
All right, thank you, Senator McMahon.
Thank you, Senator Hobson. Senator Wiggins, you are next up.
Thank you, Mr. President. I have a superseding motion. My motion is to recommit this bill to the committee from whence it came.
Motion to recommit. All those in favor signify by saying aye.
Aye.
All opposed, no. The ayes have it. It's recommitted to Judd A. Chairman DeBar. Chairman DeBar, you're recognized. We're on item 36.
Thank you, Mr. President. Call up item 36, have the title read.
Mr. Clerk, please read the title.
Senate Bill number 2307, Dyslexia Awareness Training Program, require teachers to complete 2 hours of training for.
Make the usual motions.
Senator makes the usual motion. All in favor signify by saying aye. All opposed, no. The ayes have it.
Thank you, Mr. President. Move for adoption of the committee sub in lieu of the original bill.
You're recognized to explain the committee substitute.
If you could recognize Senator Boyd to explain the bill.
Senator Boyd, you're recognized. You're recognized, Senator. Let's go.
Dyslexia, we're going to move from dead people now to dyslexia.
Please move the microphone in front of you, Senator. They cannot hear you.
Dyslexia affects 10 to 20% of the students in our state, and a number of years ago, this legislature took some steps to address these issues with establishing dyslexia scholarships and mandating screeners to be used with certain, with our first graders. The Department of Education has directed a number of resources to assisting school with this and dyslexia issues. However, we still have a few issues, and one of these issues was that when we created the code sections a few years ago, we placed the language in the statute that has made it confusing for schools. And it's caused some districts to be in violation of federal IDEA laws and 504 of the Rehabilitation Act. So what you have before you is legislation that clears up that confusion. We've taken out the confusing language at lines 23, and we have created a separate statute at line 48. We believe this bill will clear up the confusion, the students will get the assistance that they need and that they're entitled to under federal law, and we will eliminate the litigation that is being pursued on this issue. We have worked extensively with the Department of Education, Special Education Director Robin Lamotis, and we appreciate all of her hard work on this. Additionally, the department is going to be doing some training for school districts to further this matter, and I will entertain, Mr. President, I'll entertain questions at this time.
Any questions on the bill? On the substitute, I'm sorry. Any questions on the substitute?
If there's no further questions, I ask for use of the morning roll call.
One moment, please. Senator Hill, for what purpose you seek recognition?
A question.
Will you yield, Senator, for a question?
Yeah.
Please proceed.
I think I understood this in committee, but I just want to make one clarification. Does this do anything to change the dyslexia scholarship program at all? I didn't think so. Okay, appreciate it. Thank you.
Any other questions? Any other questions? We're on the substitute. Senator, ready for your motion.
If there's no further questions, I'll ask for the use of morning roll call.
Now just move to adopt, Senator.
Move to adopt.
There you go.
Sorry.
All in favor signify by saying aye. All opposed, no. The ayes have it. We're back on the bill.
I'll move for final passage.
On the morning roll call, Senator moves for final passage on the morning roll call. Anyone object to the procedure? Anyone wish to be recorded as voting no? No? Present? Seeing none, use of the morning roll call is granted. Bill is passed. Senator Barr, you're recognized.
Go to item 37, have the title read.
Mr. Clerk, please read the title.
Senate Bill Number 2305, William F. Winter and Jack Reed Sr. Teacher Loan Repayment Program create.
Make the usual motions.
Senator makes the usual motion. All in favor signify by saying aye. All opposed, no. The ayes have it. Please proceed.
If you could recognize Senator Blunt to explain the committee substitute.
Senator Blunt, you're recognized.
Thank you, Mr. President. Mr. Chairman, I'd like to move adoption of the committee substitute in lieu of the original bill and be recognized to explain it.
You're recognized to explain the committee substitute.
Thank you. Ladies and gentlemen of the Senate, this bill is part of our overall effort to deal with the teacher shortage in Mississippi. Just a few minutes ago, we passed a really good bill from Senator DeBar to deal with reciprocity among all the 50 states. Our first week out here, I think it was our first week, we passed a teacher pay raise. And this bill deals with helping attract new college graduates into the teaching profession here in Mississippi. This is what the bill does. We have had on the books for many years about 10 different programs, all of which but one are loan forgiveness programs to help attract teachers in the profession. All of them are well-intentioned, but none of them have been funded in recent years. In addition to that, in addition to the lack of any money being directed into these programs, the loan forgiveness programs are inefficient and in some cases have default rates. They vary from program to program. So what we are attempting to do today is consolidate all of those existing programs into a single loan repayment program. Now, what's the difference between a loan repayment program and a loan forgiveness program? A loan forgiveness program is something that you sign up for while you're in college. And you get the money to go to college, and you agree to go teach in a Mississippi public school, and if you do that, your loan is forgiven. But what happens, of course, is people's plans change. Maybe they choose not to go into the teaching profession. Maybe they move to another state. Maybe they teach for a year and decide they don't want to teach anymore. And then that loan is outstanding, and the state essentially has to become a collections agency to go get its money back. A loan repayment program doesn't have a default rate. The default rate is 0. A loan repayment program works like this. You graduate from college, and this is a staggering statistic. The average Mississippi college student loan debt is between $35,000 and $37,000. So most Mississippians graduate from college with significant student loans. Then we say to those young people graduating from college, if you agree to come teach in a Mississippi school, we will pay down your student loan debt. And then the teacher or the person enters the teaching profession and they teach. At the end of the year, they go to the Office of Financial Aid, and with a piece of paper it says, I taught. The state of Mississippi writes a check to that loan provider, and the principal on that loan is reduced by that amount. That's the way a loan repayment program works. So what we have here are a program that will benefit every single school district in the state. Every single school district in the state is eligible. It's a 3-year program we propose, where the first year we'll pay a certain amount, the second year we'll pay a little bit more, the third year we'll pay a little bit more. We do have an additional amount for a critical needs shortage district as opposed to another district, but again, I want to say every district is eligible. And we have a loan repayment program. We think it'll help attract people in the profession, help people, along with the raise that we've already passed, help people pay down their college student loans and give them an incentive to stay in the classroom. The program that we propose is named for Governor Winter, who of course is the architect of the Education Reform Act and has had a program in his name for many years on the books. And in addition to that, former Tupelo businessman Jack Reed, who was Governor Winter's close friend, and Governor Winter appointed him to the original State Board of Education, and they were involved till Mr. Reed passed away in working together for public education in the state. They were from different political parties, they were good friends, and they were committed to public education. So that's what the bill would do. I believe there's an amendment on the desk.
We'll first adopt the committee substitute, and then we'll go to the amendment.
Move adoption of the committee substitute.
Senators, move adoption of the committee substitute. All in favor signify by saying aye. All opposed, no. The ayes have it. We're on the amendment.
The amendment is offered by Senator Hobson. It's a reverse repealer. I support the amendment and ask you to vote for it.
1 second. It's up on the screen, Senator. 1 moment, please. It's on the screen.
There are no questions on the amendment. I move adoption.
Any questions on the amendment? Questions on the amendment? Seeing none. All those in favor signify by saying aye.
Aye.
All opposed, no. The amendment is added, and we're back on the bill, Senator.
I'm happy to answer any questions on the bill.
Questions on the bill? Seeing none, we're ready for your motion, Senator.
My motion would be passage by use of the morning roll call. Oh, I'm sorry. I'd happy to yield for a question.
1 second, please. We will start with Senator McDaniel. Senator McDaniel, you're recognized for a question.
Thank you, Mr. President. Mr. Chairman, Senator, I apologize. I was running up the stairs. I'm out of breath. So
that's all right.
I'll do my best to answer the question.
I get out of breath more than I used to.
I heard a personal explanation. Has there been any discussion of the overall cost of this program to repay these loans?
Yes, that's a good question. Thank you for asking that. The numbers in the bill, and the numbers are subject to change, which is why we just adopted Senator Hobson's amendment, are for a critical needs shortage district, $4,500 the first year, $5,500 the second year, $6,500 the third year. For a non-critical needs shortage district, $2,500 the first year, $3,500 the second year, $4,500 the third year. Now, we have no way of knowing how many new teachers we'll get each year. I will tell you the average. the average number of new licenses issued over the last 3 years by the Department of Education is 1,363. We have no way of knowing, let's just say it ends up being that number, how many of those teachers are going to go to a critical needs shortage district and how many of them are going to go to a non-critical needs district, which will affect the total cost, because the critical needs district costs a little bit more than the other under what we're proposing. But I just ran some back of the envelope numbers this morning because I anticipated your question. It's a good question. If 80% of the teachers go into a non-critical needs district and 20% go into a critical needs district, and I don't have any way of knowing, that's just a number I made up, then you're talking about $3.9 million first year.
3.9.
3.9, yes, sir.
That will be each year. And that money's coming from the general appropriations?
Yes.
Okay. Is the idea to pay back the entirety of these teachers' loans over time? Is that the idea?
No, it is not. If you, under what we're proposing, and again, these numbers are subject to change, if you go to a non-critical needs shortage district and become a teacher, your total award, not your award, the amount that goes to pay down your college loans would be $10,500. So if you graduate with the average amount of college student debt in Mississippi and you owe $35,000, you still owe $25,000. But we would have paid down $10,500 of your loan.
Thank you, Mr. Chairman.
Thank you.
Other questions on the bill? Thank you, Senator McDaniel. Other questions on the bill? Senator Jordan, you're recognized for a question.
Thank you, Mr. President. Senator Blunt, just one simple question. For those critical districts, this is an incentive to get people to go there because usually they can't get teachers. And that's what this is, an incentive?
It is an incentive. It's an incentive that is available to every school district in the state, but under what we're proposing, we've got a little bit more incentive for those critical needs districts.
Yes.
And the definition of that is set by the State Board of Education.
Okay, that's what I'm... Thank you, Mr. President.
Thank you, Senator. Other questions? Other questions?
If there are no other questions, Mr. President.
We have one other one. Senator Polk, for what purpose you seek recognition?
Question, Mr. President.
Will you yield for a question, Senator?
Yes, I do.
Let's proceed.
Thank you. Thank you, Mr. Chairman. You mentioned just a moment ago that the Board of Education would decide what the definition of critical. Has that determination already been made, or they will make it?
That's a long-standing their definition of that is long-standing.
So it's there. We could look at it right now. We know what it is.
Yes, sir. There's a list. The chairman just gave it to me this morning. They go through a process every year based on their criteria, which deals with how many teaching positions have people who aren't licensed, how many teaching positions in that district have people teaching in a subject that they're not licensed or approved to teach in. They have a definition. Every year, they run the numbers through every district, and they get a number.
So that could change each year?
It does change each year.
Okay, thank you.
Thank you, Senator Polk. Other questions? Other questions from the senator? We're on the bill, Senator. We're ready for your motion.
Passage by use of the morning roll call.
Senator moves for passage use of the morning roll call. Anyone object to that procedure? Anyone wish to be recorded as voting no? No. Senator McDaniel? No. Senator Sojourner? Anyone else? No. Seeing none, use of the morning roll call is granted with those two exceptions.
Mr.
And
President.
the bill is passed. Yes, sir.
Ask for unanimous consent to be added as a co-author.
Unanimous consent to be added as a co-author. Senator Barr, yes. We're going to go through this at the request of the Senate. We're going to go through this one at a time. So we'll start on the left. Mr. Secretary, would you help me? Senator Parker, Senator Boyd, Senator Parker, Senator Boyd, Mr. Clerk. Senator, let's see, Kaufman, Butler, Blackwell, Chazanall, McMahon, Williams, Sparks, Barrett, Barnett, Witherspoon, McClendon, Simmons, Jackson, Thomas, Jordan, Simmons, Jackson, Frazier, Norwood, Frazier and Norwood in upstairs. Is there anyone else? Okay, Mr. Clerk, would you read the co-sponsors?
Add as co-sponsor, Barnett, Barrett, Blackwell, Butler, Kaufman, Chazanal, DeBar, Frazier, Jackson of the 11th, Jackson of the 32nd, Jordan, McLendon, McMahon, Norwood, Parker, Simmons of the 12th, Simmons of the 13th, Sparks, Thomas, Williams, Witherspoon.
Okay, Senator Jackson, your light is on. Senator Simmons, are you good? Okay. Senator Younger, good?
I'd like to ask to be co-author on 2307, unanimous consent, please.
Okay, on the previous bill, we're unanimous consent is granted, seeing no objection. And yours is which one, Senator Younger? 2307. Seeing no objection, it's granted. Motion granted. Back on the calendar, Senator Barnett, you're recognized. We're on item 38, gentlemen.
Thank you, Mr. President. I call up that bill and ask for the title be read.
Mr. Clerk, please read the title.
Senate Bill number 2553, State Offenders in County Jail, bring forward sections relating to.
Senator makes the usual motion.
Sir makes the usual motion. All in favor signify by saying aye. All opposed, no. Ayes have it. Please proceed.
Thank you, Mr. President. I'd like to take up the committee sub in lieu of the original bill.
Senator, you're recognized to explain the committee substitute.
Thank you, Mr. President. This time I will ask Senator Sparks to come and explain the bill.
Senator Sparks, you're recognized.
Thank you, Mr. President. Thank you, Mr. Chairman. Senate Bill 2553 addresses two unique issues. One we spoke of last year, where a county board of supervisors or sheriff may request, it is not a mandate, but they may request on, I believe, line 37, that an inmate serve their time in the county jail. The Department of Corrections will determine whether or not that they're going to allow that, and if it's denied, they will tell that county why in writing. If a county requests someone under this circumstance, it is zero cost to the state. The county bears that cost. The only language that was allowed was county of conviction. We're adding the language or county of request, assuming maybe the county of residency is willing to take someone, but they committed a crime in another county, they can simply make that request. That's the only issue as to that portion. The remainder of the bill addresses the daily rate for county inmates that are actually sentenced to the custody of MDOC. We have several sheriffs across our state and county jails where MDOC inmates are being left for exorbitant periods of time, and they are receiving a maximum of $20 a day. They would prefer to have the open slot in their jail. Many of our county jails are also holding inmates for other counties, and they are also the place where a city offender would be brought upon arrest. So what we have encouraged the department to do is come pick up their inmates. And the way we're going to encourage that, we're going to state that 5 days after the sentencing order is sent, or upon receipt of the sentencing order by the Department of Corrections, that the state shall pay up $25 for the first 30 days. If you have been convicted and you are in MDOC custody, or you've been revoked in your MDOC custody and you are left at the county jail, on day 31, it moves to $30 per day payable to the county jail. If you have left the MDOC inmate in the county jail 60 days, on day 61, it goes to $35 a day. I've spoken with the Department of Corrections. I've spoken with Commissioner Kane directly. I've explained that this is a problem we're having across the state, that our sheriffs are suffering, our counties are suffering. We don't want the state to pay any penalty rate. They just need to come pick up the inmates. The only other thing this bill does is it raises the amount to, and that's a separate issue. I want to make sure you don't get these two things blended. If the state does not have room and this is not regional jails, these are county jails, these are county inmates. If the state does not have room and wants to send people to the county jail, up to $25, and that's a up to number, that's not a shall pay. If you have left them that are your custody in the county jail, it's a shall pay. If you need to send them because you do not have space in MDOC, and that's not the circumstance this time, but they have three options on line 57. Actual cost, they can do a contract. The state can enter a contract with the county. If they don't do either one, it's up to $25. So I would yield to any questions, Mr. President, if there are any.
Questions on the bill? We have several. Senator Hill, for what purpose do you seek recognition?
Question.
You're recognized for a question. Please proceed.
You may or may not have been aware of this. I guess I'm asking you. Have you been aware of inmates being left for substantial periods of time and the county's just holding the tab?
Yes, Senator.
I also have, Marion County, I represent that area. They're one of the few regional that can hold female inmates. And you may or may not realize, but I guess my question is, do you realize that they owe Marion County over $300,000 for female inmates that were left there for 7 months? And I filed letters, I sent certified letters to Commissioner Hall. I did everything in my power to try to get that bill paid. But do you know to this day that they have not been paid and they house those inmates for free for 7 months?
I'm not aware of that particular issue, but that's exactly what this legislation is hoping to remedy.
Well, I wish we could make it retroactive. Is there any way we can get my county paid?
Well, I think if they have a claim under law as it existed, I'll let their county attorney handle that issue. But the other thing I want to make clear, and I think this is the same with your question, Senator, this is not a COVID issue. This is not something where we're upset because something happened in COVID. This is what was happening before COVID.
This was at least 4 years ago. So, I would really like some kind of way to get my county compensated. I've tried to get it in appropriation bills. I've tried every way I know how, certified letters, and all I could be told is, well, it was their mistake. They should have sent them back. So I appreciate what you're doing.
Thank you, Senator.
Thank you, Senator Hill. Senator Seymour, for what purpose do you seek recognition?
Question, Mr.
Will you yield
President.
for a question, Senator?
I do yield.
Please proceed.
My question is not the state's estimate. I've seen on a couple of reports, the cost per inmate roughly at $51.
You know, Peer, I don't want to besmirch what fine work that Peer does, but, you know, they have given a number that's $51, $52, $53.
Well, just roughly $51.
That's right.
Our private jails, we pay even more than that. Why are we not coming to a better average for our counties? I mean, $25.
Sure, I'll be glad to try to answer that. First of all, we don't have any private prisons in the state of Mississippi. I think that's something people need to understand. All of our prisons are state facilities. There are some facilities that are operated under a contract basis with a private contractor for supervision, food, etc. That number in the prior contract was $38.72 a day. So I believe that was the number. Now, I understand under the COVID concerns, and early last year we had some people taken to Tutwiler at a different number. I think that was almost an emergency type issue, but the standard contract was $38.72. The number as it relates to the $53 number, I think includes all of your salaries of administration. I don't think that is an incremental cost per inmate. So I don't want to say, hey, we ought to pay $50 to everybody that houses an inmate. That's not what this bill is intended to do. The county jails are not built to house inmates. And if you actually look, it's not the purpose, but the statute that we amended, if 475903, we're talking about people that are sentenced and the county jail wants to bring them back to them. We understand that that's the issue, but it is the intent of the legislature to move people out of the county jails as quickly as possible into our state system, and that's 475907, which is Section 4. So what we're trying to say is take them out of the county jails because they've not yet been classified, Senator. We potentially have close custody inmates or female inmates, as Senator Hill stated, that are left in our county jails, and our sheriffs are having to juggle that. MDOC is equipped and built to do that job. Just come get your inmates. That's all we're asking.
Thank you.
Thank you, Senator.
Thank you, Senator. Senator Younger, for what purpose you seek recognition?
Friendly question, Mr. President.
Will you yield, Senator?
I yield.
Please proceed.
And thank you, Mr. President. Thank you, Mr. Chairman. You and Senator Barnett, y'all have done a great job. But have we done anything about classifying these prisoners? They all have to come to Rankin County to be classified. I think it's just really crazy that we can't do classification in our own districts or in our own prisons with the technology we have.
And that's a very good question, Senator. There is a provision to classify prisoners at the county jail. We've talked with the commissioner about that. Senator Barnett has talked with the commissioner about that. So we expect MDOC, and he's still a year on the job, and he's had a difficult year, and I think he's doing some great work. But I do think that is a legitimate question, particularly if you're going to leave them in our jails. So, but the classification procedure generally happens at Pearl, but it actually can happen in the county jail.
Thank you so much for y'all's work.
Thank you, Senator.
Thank you, Senator Younger. Senator Hobson, for what purpose? Senator Hobson is good. Senator Wiggins. Senator Wiggins, for what purpose you seek recognition?
Question.
Will you yield for a question, Senator?
I yield.
Please proceed.
Thank you, Mr. Vice Chairman. You and I have talked briefly about this. I just want to make sure, starting in lines 34, where it talks about the requests, is it your position that the language that's in that section, starting at line 32, about a county requesting an inmate to serve there, that's not mandatory, that's just a request, and that actually MDOC can choose not to honor that request? Is that your understanding?
That's correct, Mr. Chairman, and I appreciate that question. They may serve, and of course, if you look to 36, the last word is if requested, request being the last word on line 37, and then of course the key word 38 and 39, the department may allow. It is the department's discretion. And then on line 43, the determination, which means they're making the decision, shall be promptly made by the Department of Corrections. And then on line 45, when a request is denied, the department can deny that request. They just need to tell the county in writing why they denied it. So it is the department's discretion to allow a MDOC inmate to go back to a county and serve their time. Yes, sir.
But for that to happen, the sheriff or the board of supervisors has to make the request in the first place.
That's correct. Yes, sir.
Okay. And as I've shared, my concerns are that it may be somebody's brother or something and they're getting favorable treatment, and we just want it to not be ripe for abuse. But if the MDOC makes that decision, then it seems fine.
Yes, sir, and of course, the county is going to bear the entire cost of that incarceration if they choose to bring someone to their county.
Okay, thank you.
Thank you, Mr. Chairman.
Senator McClendon, for what purpose you seek recognition?
Friendly question, please.
Will you for a question, please?
I yield.
Please proceed.
Thank you both for working on this, Sheriff Bill Rasco in DeSoto County and Chief Jail Administrator Chad Wicker. I know you've talked to both with this. The municipalities in DeSoto County currently, all 5, pay $35 a day to hold their inmates. What happens if one of these state inmates has a medical condition? Does the county absorb that, or does that go back to the state?
The state is responsible for the medical cost while they're in the county jail in addition to the daily rate.
Thank you, sir.
Thank you.
Thank you, Senator McClendon. Any other questions? Any other questions? We're on the committee substitute, I believe. Senator, I think we're ready for your motion.
I'd move for adoption of the committee sub.
Senator Bryan, one moment, please. Senator Bryan, for what purpose you seek recognition? He would like to speak on the bill. Senator Bryan is recognized to speak on the committee substitute.
I think this is a very fine bill. I'm going to vote for it. I encourage everyone to. But there was a mention of privatization, and I think it's one of the many discussions which causes me to have some something similar to post-traumatic stress syndrome. I was here when we got off on so-called privatization of prisons. And the Mississippi Economic Council at that time was very big on privatization, and they announced that if we would privatize things, we could save 10%. The reason they said we could save 10% is they checked around and found that we have a decimal system, is my understanding. So we had a number of arrangements with various prisons and bond issues for these 2 county operations and everything in the world. Number one, it produced incredible amounts of fees for some well-connected people to get paid money for doing who knows what, if anything. The notion was that the counties would make money by housing the prisoners. That was a big mess. The other thing that took place is we have these prisons which we've got contracts with folks to operate. The contracts say that they will get 10% less, or at least, we have to save at least 10%, and the peer committee is to report on this every year. And year after year after year, you can go find the peer committee reports. The peer committee says, yes, the per prisoner cost here is cheaper than the per prisoner cost at Parchman. Number one, they don't have to take difficult prisoners. Under their contract, if they have a difficult prisoner, they can send him back to Parchman. Number two, they don't have any of the services that Parchman has. They don't have job training, they don't have any literacy, none of that. All they do is warehouse prisoners. And so it's not a fair comparison to say that this group of prisons, which offers limited services and which does not have to deal with difficult prisoners, is the equivalent of Parchman, which is trying to offer these services and deal with the difficult prisoners. Pierce said that every year. It was ignored, and we went on. So it's just to be in my bonnet, because once again, we have a situation where we've got some well-connected private people that got these contracts, muttered the word privatizations 3 times before the cock crowed, got them a great contract, and the comparison between what they're doing and what the state is doing is just dramatic. And it's been a burr in my saddle. It continues to be a great source of frustration. And so, having heard this issue brought up, I felt compelled to come rant. Thank you.
Thank you, Senator Bryan. Any other comments? Anyone else want to speak on the bill? Seeing none, we're ready for your motion.
I move for adoption of the committee sub.
Motion is to adopt the committee substitute. All in favor signify by saying aye. All opposed, no. The ayes have it. We're ready, we're ready for the bill.
Move for final passage, Mr. President, on the morning roll call.
Final passage for morning roll call has been requested by the senator. Anyone object to the procedure? Anyone wish to be recorded as voting no? No. Present. Hobson, present.
I want to be added as a...
Okay, 1 second. Hobson, present. Anyone else? Turner Ford, present. Present. Turner Ford. Anyone else? Anyone else? Hill? Okay, just 1 second. We'll go to co-authors. Okay, so the bill has passed. Use of the morning roll call with 2 presents. Now we'll go back to Senator Barnett and your requester. I'd like to be added as a co-author. Anyone else? Anyone else? Mr. Secretary, if you'd come up, we'll start on the left. Chisholm? Butler? Williams? McClendon? Thomas? Simmons? Jackson? Jordan? Simmons? Seymour? Hill, Kahn, Thompson. Upstairs, Senator? Norwood. Anyone else? Anyone else? Would you read the names, Mr. Clerk?
No, it's Jackson of the 11th. Jackson 11th. Williams.
Voting, asking to be co-authors, Barnett, Butler, Chisholm, Hill, Jackson of the 11th, Jordan, McCon, McClendon, Seymour, Simmons of the 12th, Simmons of the 13th, Thomas, Thompson, Williams.
Okay, we're ready. Back on the calendar, Senator Tate, you're recognized.
Thank you, Mr. President. I'd like to call up item number 39, Senate Bill 2113, and ask that the title be read.
Mr. Clerk, please read title.
Senate Bill number 2113, voting equipment requires certification by the United States Election Assistance Commission.
I make the usual motion.
Senator makes the usual motion. All those in favor signify by saying aye. All opposed, no. The ayes have it. Please proceed, Senator.
I'd like to call on Senator Blunt to explain the bill.
Senator Blunt, you're recognized to explain the bill. I think we have a committee substitute first.
Yes, sir. Thank you, Mr. President. I move adoption of the committee sub and ask to be recognized to explain it.
You're recognized to explain the bill.
Thank you, Mr. President. Chairman Tate, Senator Tate filed this bill, and when I saw it, I was excited to see it. I think it's something that we've been needing to do for a long time, and it deals with voting machines. All of us want accurate voting machines in the state. And as you know, the voting machines are bought and paid for and selected at the county level. That's the way it is in Mississippi. That's the way it is in most states. And so how do we know that those machines that are selected at the county level are accurate and reliable and can't be hacked and give the true result of the election? The counties and frankly even small states like we have do not possess the resources to get the computer people, the technology people to put these things through tests, to know all the different machines that are manufactured in the United States and set standards that are very detailed for how we know that that machine is going to yield a true and accurate result. Well, who can do that? The Federal Elections Assistance Commission can do that. They were established by the Help America Vote Act in 1993. The election, I want to emphasize this, the Election Assistance Commission is run by 4 people, 2 Democrats and 2 Republicans by statute. The current commission has 2 commissioners appointed by President Obama, has 2 commissioners appointed by President Trump. But what they especially have is they have task forces of these computer technical people who can take machines apart and know that they're secure and set standards. So what the bill would do is say that when a county decides to purchase new voting machines, that the machine they purchase has to meet or exceed the federal standards set by the United States Elections Assistance Commission. There are different companies that do that. Look, as of right now, that's county money. They can make that pick. But we want to know whatever they choose, that they're buying machines that are accurate and secure, and this bill will do that. I'm happy to answer any questions on the committee sub.
Senator Whaley, for what purpose you seek recognition?
Question, please.
Will you yield for a question, Senator?
Yes, I do.
Please proceed.
Thank you, Mr. President. Thank you, Senator Blunt. When we're talking about the Federal Election Assistance Commission, do they have a standard as far as who is up to standard and who is not?
Yes.
Is that list available where we can see
The
what names
website
may be on that?
is eac.gov. They can't make anybody do anything. Their standards are voluntary, but what the bill would do is say that Mississippi would go by those standards, and they're updated periodically as new machines come out. So if you want to know if a particular company their machine meets that standard or not, I mean, if I was a board supervisor, if I was on the board of supervisors and a salesman came to me and says, I've got these great new voting machines, the first thing that I would ask is, have your machines been certified by the EAC or not? And that's a yes or no question. So I don't know if the list is not on the website, I'm sure it's available. And if you have a concern about a particular manufacturer, I'm sure you can ask them.
Thank you.
Thank you, Senator Whaley. Senator Hill, for what purpose you seek recognition?
Question.
Will you yield for a question, Senator?
Yes.
Please proceed.
I don't know if you have, maybe you have not, but have you had people contact you and ask you about like a paper tally I know that there are machines that you can hook that printer up to. Council can tell you the name of it. I can't remember it, but I had a bill to require the computerized machines to have that paper printout. You know how it's rolling down the floor when the votes are cast, so that there's no question that somebody could change the results after the votes have been cast. You'd have that paper trail. Any thought to, I think some do it, some don't in the state of Mississippi, from what I agree. And I mean, I had a bill that would make it mandatory for that paper trail at each precinct. Do you have any thoughts or considerations to that to ease the mind of people of hacking these machines and different things? Because we watch people hack the machines on video. We know that can happen. So I think if we're looking at election confidence, maybe y'all would be willing to look at a requirement that these computer machines would have this paper trail. Would you have any objection to that?
No, I wouldn't. Senator Tate and I were talking, Hinds County and Lauderdale County have the same type of machines, and we have the scanner machines where it's on a piece of paper and you blacken in the oval and slide through. Those are what I prefer.
Right, but some have those that you just, you know, poke the machine, and there's not always a printout back there.
You're right, and you know I'm not the chairman and I'm not the Secretary of State, but what I would love to see us do is we still have counties operating under the machines you're talking about that were bought in 2002 that are touchscreen machines. And what I would like to see is for the state to come up with revenue to help every single county in this state purchase new paper scanner machines and reimburse the counties that have already done that, so that everybody in the state has the same machine. It's a paper ballot with a paper trail, and everybody's operating off the same machines that are secure and accurate and approved by the EAC.
Have you looked at a financial analysis of what that would cost?
It's hard to raise new money in this chamber, but
well, I'm just curious as to what you think the total might be.
I think Secretary Watson is looking at that. I think it would be great to do.
That might be something I could support after I see what it's going to cost.
Well, I think Secretary Watson has looked at that, and I think that if that happens, that's why we need something. I think if the Secretary of State's buying it, you know that they're going to.
And we need some kind of watermark on the paper too, or something to show that it's the correct ballot, and it's not a ballot printed outside the state and hauled to other states on a postal truck or 18-wheeler. We just got to do whatever we can to provide confidence for people to vote.
Well, first thing, I don't know if I want to chase that rabbit or not, Senator Hill. First thing I would say about confidence is don't believe everything you see on the internet. But I agree with you on the voting machines. I do.
I don't have confidence on everything I see on the internet either, but I've seen enough as a poll watcher to have concern with our elections. Thank you.
Yes, ma'am.
Thank you, Senator Hill. Senator Jordan, you're recognized for a question.
Thank you, Mr. President. Senator Blunt, do you have a record of voter fraud in Mississippi? Anybody have a record?
Senator Jordan, I think there's another bill on the calendar that with your permission, I'd like to hold my comments on that topic. I think this is a pretty narrow bill, and I think it's a good bill, and I think you and I think the same way about this, but I'd like to hold my thoughts on that if I'm...
Sure. I understand. I appreciate that. And consistency would be that the state could buy the same kind of machine for each of the 82 counties, and we will have some consistency in that, rather than getting different types of devices and some printouts and some not. What's your feeling on that? When we started with voting machines, we did that in my area.
Again, that's not addressed by this bill. That's what I would like to see. But the way it is right now, of course, that's a county by county decision. And that's why we need this bill, to make sure that every county out there, as right now making that decision, buys something that we can all trust.
Yeah. But you say that if the state put revenue in the counties to purchase a machine, then they would be somewhat required to be consistent in purchasing. Wouldn't you think so?
That's what I would like to see, yes.
Okay. Thank you, sir.
Thank you, Senator Jordan. Senator McMahon, you good? Anyone else? Any other questions? Any other questions? Seeing none, we're ready for your motion.
I would move that we do adopt the committee substitute.
All those in favor, please signify by saying aye. All opposed, no. The ayes have it. The committee substitute is adopted. We're ready on the bill.
Final passage by use of the morning roll call.
Senators moved by final passage by use of the morning roll call. Anyone object to the procedure? Anyone wish to be recorded as voting no? No Whaley? No on Whaley? Anyone else? Anyone else? Seeing none, passed by the use of the morning roll call is granted. Bill passed. Senator England.
Thank you, Mr. President. I would ask for unanimous consent to be added as a co-author of Senate Bill number 2113.
Senators asked for co-author, unanimous consent of co-author. Senator Jordan, same request. Senator Butler, same request. Anyone else? Anyone else? Thomas, Blunt, Jackson, Witherspoon,
Robert Jackson, 11.
Barnett, Sarita Simmons, Derek Simmons, Frazier. Anyone else? Anyone else behind my head up here? Norwood, Sampson, Jackson. Anyone else? Thank you, Senator England. Anyone else? Seeing none, read the names, please, sir.
Asking for unanimous consent to be added as co-author. Norwood, Sampson Jackson, England, Jordan, Butler, Thomas, Blunt, Robert Jackson, Witherspoon, Barnett, Sarita Simmons, Derek Simmons, and Frazier.
Granted. Motion is granted. Back to you, Chairman Tate. We're on item 40.
I ask that items number 40 and 41 retain their place on the calendar.
Retain the place on the calendar. 42, Senator Jordan. Expect this will be the last one this morning.
Thank you, Mr. President. I ask that the title be read.
Mr. Clerk, please read the title.
Senate Bill number 2278, Uniform Controlled Substances Act, revised schedules.
I make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye. All opposed, no. The ayes have it. Senator, you're recognized.
Thank you, Mr. President. This bill is just each year, according to policy, we have to adopt or regulate our schedule to be congruent with the federal schedule. So that's all this bill does. This bill amends section 412913 to conform Schedule 1 of the State Controlled Substance Act of the federal schedule at the recommendation for the State Department of Health. The drug added to Schedule 1 have no legitimate medical use and have a high potency with great potential to cause harm. A number of these drugs are also added to the state schedule at the request of the Mississippi Crime Lab. This bill is also amended section 4129-115 to revise the chemical name of fentanyl on Schedule 2. Last, at the request of the Mississippi Department of Health, the bill includes two drugs in section 41-29-119, Schedule 4, because the Federal Drug Administration recently approved the drugs for medical use. So that's what the bill is about. It's a matter of changing the schedule, make it congruent with federal laws or new bills, new medicines that have been put on. That's what it does. If no questions, if there are any questions for the questions.
Any questions of the Senate?
From anyone?
Any questions from the Senate? We have none, Senator. We're ready for your motion. I'm sorry, hold on. Senator Hill, I apologize, Senator, I didn't see you. Senator Hill, for what purpose do you seek recognition?
a question.
We yield Senator for a question. If you will, please proceed.
Thank you, Senator Jordan. This may be a question that council has to answer. I'm trying to Google the names of some of these drugs. So I think try to see what we're scheduling. Does council have any of the common names of these drugs or what they truly are? Because these chemical names, I have no idea what we're putting on Schedule 1.
Well, they have names, it's about 9 of them.
Mm-hmm.
And we can start naming those isonitrotoluene.
I mean, I see those, Senator Jordan, I just don't understand them.
Beg pardon?
I said, I see them, I just don't understand them. I thought that maybe council had a different description rather than that name. But I thank you, sir. I appreciate your indulgence.
You bet.
Thank you.
No further questions.
Thank you, Senator.
Mr. President, that is to be adopted by the morning roll call.
Senators move for adoption by the morning roll call. Anyone object to the procedure? Anyone wish to be recorded as voting no? No. Present. Seeing none, the bill is passed by use of the morning roll call. Senator Hobson, did you have a question on the bill?
No.
For what purpose?
I'd like to hold item 38, Senate Bill 2553, on a motion to reconsider. Thank you.
2553, Mr. Motion to reconsider. Form the chair. Okay, anything else? Anything else? Okay, Senator Blackwell, hold on. Senator Chisholm, did you have? For what purpose, Ms.?
Adjourn in memory out of order, sir. at the
Please
proper
proceed.
time. Thank you. Today, when we adjourn in memory, I would like for us to remember a man that was well known in Mississippi, Jim Weatherly. He's a former star quarterback at the University of Mississippi, and he moved to Nashville and authored mega hits such as The Midnight Train of Georgia. So when we adjourn, could we please adjourn in memory of him? Thank you.
Thank you, Senator. Senator Michelle.
For announcement, please.
Please proceed.
Mr. President, we're blessed to have a great group of senior pages, and I'd like to single one of them out. Micah, would you raise your hand? He's on the south side of the floor. Micah, in addition to working 40 hours a week for us here at the Senate, in his spare time 2 Saturdays ago, took the law school admittance test and made a 170, and I'm told that's the top 97th percentile. So we want to congratulate you, Micah.
Yeah. Just stay in Mississippi. Senator Derek Simmons, for what purpose?
Thank you, Mr. President. I'd like to hold item 122 on yesterday's calendar, Senate Bill 2373, motor fuel sales, on a motion to reconsider.
23. Did you get that? Would form the chair. Senator Johnson, for what purpose?
Thank you, Mr. President. I'd like to hold a bill from yesterday's calendar, item number 168, Senate Bill 2787, on a motion to reconsider.
2787, form the chairman. Thank you. Senator Simmons. Sarita Simmons? For what purpose, Senator?
To request unanimous consent to be added as a co-author on item number 60 on yesterday's calendar.
Seeing no objection, consent is granted. Senator McCon. For what purpose, please, sir?
Thank you, Mr. President. For an announcement.
Please proceed.
First, just a point of personal privilege. I appreciate the Senate for checking in on me yesterday. We as a family, you don't ever know when something's going to happen. So all of you that checked in, I appreciate that. And thanks for covering for me there, Mr. President, while I got back in here. Second thing, on a good note here, the Senate has kept the legislative showdown in our chamber for a whole year. And on Monday of next week, you may have seen a sheet on your desk. We would like to continue to keep the legislative showdown belt buckle in the Senate chamber. So if you have a 4-H kid that's showing the next week, I encourage you to go down there and check with them. Get lined up to show, because it's a good time and those kids really enjoy it. If you have any questions about the legislative showdown, you can catch myself, Senator Whaley, or Senator Younger, and we'll be sure to find you a kid to show with. It's a great thing for these kids. They're out there doing their best to keep them groomed, trained, and have them out there. But next Monday night, or this coming up Monday night, is when the legislative showdown is. Let's have a good showing. Thank you, Mr. President.
Thank you, Senator. Senator Whaley, for what purpose?
Announcement.
Please proceed.
Thank you, Mr. President. I'd also like to add a little bit to what Senator McCon said. the senators were competing against each other, so I want to invite everyone to come participate for second place.
Okay, and there's your showdown right there. Senator Turner, for what purpose you seek recognition?
Motion to reconsider.
Please proceed.
I'd like to request that item 120 on yesterday's calendar, Senate Bill 2521, be held on a motion to reconsider.
Is that one already held? 120? Thank you, Senator. Form the chairman. Okay, all business done. Senator Blackwell, you're recognized.
Thank you, Mr. President. I move to stand in recess till 1:30 today.
Senator makes a motion to stand in recess until 1:30. All in favor signify by saying aye. All opposed, no. The ayes have it. We stand in recess. Hold on. Number 43, be Senator Wiggins. Senator Wiggins.
Thank you, Mr. President. Go to item number 43, call that up, ask the title be read.
Mr. Clerk, please write the title.
Senate Bill number 2087, cemetery owners authorized to disinter dead human remains for reinterment, reburial, or delivery to a carrier for transportation.
Make the usual motion.
Senator makes the usual motion. All those in favor signify by saying aye.
Aye.
All opposed, no. The ayes have it. Senator, you're ready.
Thank you. We're going to try this one. This is a cemetery bill, and in short, no, sit down, Senator McMahon. In short, like I said, there are some issues in cemeteries. Section 1 of this bill is the new language. In short, it's really just allowing the owners to be able to not be able to have notice when there's disinterments going on. And in Section 1, if they're the next of kin, or by a court order, or by if there was an error in the original burial, then the disinterment can take place, and the cemetery owners are notified of that. And that's really all that it does. And part of this is coming from a lot of the different things that are going on with the true crime shows and stuff like that. Believe it or not, people are just going out onto cemeteries and disinterring bodies, and this just allows the owners to have notice. And so with that, I'd be happy to answer any questions.
Questions on the bill? Questions on the bill?
Move passage on the morning roll call, Mr. President.
Senator England, for what purpose do you seek recognition?
Question, Mr. President.
Are you for a question, Senator?
No. Not with that mask. Yes.
All right, go ahead, Senator England. You're now recognized.
Senator, I'm just wondering, I'm looking at the title of the bill, and it says to authorize to disinter dead human remains. Are we going to do anything with live human remains, or are we just going to keep it with dead?
My goal would be to keep them dead.
Okay, thanks, Senator.
Thank you.
Thank you, Senator England. Any other comments? Okay, we're ready for motion, Senator.
Move adoption on the morning roll call. Passage on the morning roll call.
Passage on the morning roll call has been requested. Does anyone object to the procedure? Anyone wish to be recorded as voting no? Present? Seeing none, bill passes on the morning roll call. Turner forward, Senator Turner forward, pass. Items 44, 45 will retain their place on the calendar. Chairman Parker, pass. Item 46 retains its place on the calendar. Chairman DeBar.
Thank you, Mr. President. If we could skip item 47, have it retain its place on the calendar, and go to the next item, have the title read.
47 changes its place on the calendar. Mr. Clerk, please read 48.
Senate Bill number 2664, Early Learning Collaborative Act of 2013, prescribes standards and benchmarks.
Make the usual motions.
Senator makes the usual motion. All those in favor signify by saying aye.
Aye.
All opposed, no. The ayes have it. Please proceed, Senator.
If you could recognize Senator Wiggins to explain the bill.
Senator Wiggins is recognized to explain the bill.
Thank you, Mr. Chairman. This bill concerns the early learning collaboratives that we're all familiar with or should be familiar with, and the success that we've had with those. There was a peer report that came out 2 years ago that talked about some tweaks that needed to be done. And by the way, that's a function of the initial legislation that required peer to look at it. And so what this bill does is makes those tweaks to it, and it also is requiring the 2 additional benchmarks to be put into statute by the National Institute of Early Education Research, which that has allowed us to get that top 5 rating in the country by having these benchmarks. We want to continue the success that we have. And so by doing that, by doing this legislation, we can continue with the use of that. And so with that, I'd be happy to answer any questions.
Questions on the bill? Seeing none, we're ready for a motion, please.
Adoption, passage on the morning roll call, Mr. President.
Senators move adoption of morning roll call. Anyone object to the procedure? Anyone wish to record his voting? No. Present. No. Present. Senator Hill, present. Anyone else? Anyone else? Okay, we're good. Passed by use of the morning roll call, Mr. Clerk. The bill passes. Senator Barr, you're recognized. We're on 49.
We can have the title read.
Would you read the title, Mr. Clerk?
Senate Bill number 2527, Mississippi Critical Teacher Shortage Act, extend repealer on.
Make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye. All
Aye.
opposed, no. The ayes have it. Please proceed.
Thank you, Mr. President. We have a committee sub, and I'd be asked to explain the committee sub.
Senator is recognized to explain the committee substitute.
The Critical Teacher Shortage Act, this is just a repealer bill, repealing it, extending the repealer for 3 years. If you recall, we brought these up last year, passed a 1-year repealer. We looked at it because there was some potential issues regarding default rates and so forth. We looked into it. The default rate really is only 7% on the housing loan repayment program. And so that's why we decided to extend the repealer for 3 years. And what this does, there's 3 sections in it. Section 2 provides for up to $1,000 for potential teachers to relocate to a critical teacher shortage area. Section 4 provides for the University Assisted Teacher Recruitment and Retention Grant Program, and that provides up to $6,000 to buying homes. That provides for teachers in the critical shortage areas to obtain a master's degree in education or an education specialist. And then Section 5 is the Employer Assisted Housing Program, and that awards $6,000 as far as a $6,000 loan for teachers who move to these critical areas, which becomes an interest-free grant if they remain in that critical area for 3 years. And I'll be happy to answer any questions.
Questions on the bill? Questions on the bill?
If there are none, ask for passage by use of the morning roll call.
We need to pass substitute first, Senator. Make your motion, please, to adopt the substitute. We got to adopt the committee
Okay,
sub.
move for adoption of the committee sub.
All those in favor signify by saying aye.
Aye.
All opposed, no. The ayes have it. We're on the bill, Senator.
Ask for passage by use of the morning roll call.
Senators request the use of the morning roll call. Anyone objects to the procedure? Anyone wish to record as voting no? No. Any present? Present, and seeing none, the bill is passed. Use of the morning roll call. Senator, you're recognized on item 50.
Thank you, Mr. President. If we could skip items 50 to 53 and have them retain their place on the calendar.
Items 50 through 53 retain their place on the calendar. Chairman Branning. Or Vice Chairman. Chairman Horn. Good. 54 to 57 retain their place on the calendar. 58 and 59 retain their place on the calendar. Chairman Moran. Senator Moran, you are recognized.
Thank you, Mr. President. I'd like to call up item 60, Senate Bill number 2392, and ask the title be read.
Mr. Clerk, please read the title.
Senate Bill number 2392, County Port and Harbor Commission, provide for holdover of appointees.
Make the usual motion.
Senator makes the usual motion. All those in favor signify by saying aye. All opposed, no. The ayes have it. Please proceed, Senator.
It's a real simple bill. What this does is it basically only helps and takes effect every 4 years when the governor and lieutenant governor and the supervisors appoint, or supervisor governor appoint new appointees to these different county boards, like our economic development, known as the Port and Harbor Board. The problem that we get into is that as the former members roll off board, their time is done. The new ones, there may be a month or so gap in there between the time that they get vetted and be ready to be on the board. So what we got into last year was, there was 2 or 3 meetings there where they didn't have a quorum because the old ones had already rolled off the board. The new ones had not gotten their liability insurance anyway, so they had a problem with that. What this does is, it wouldn't even really be enacted until about 3 years from now when the new board's put in place again. There again, once again, they'll have that problem with not having a quorum. So all this does is says that the members that are currently on the board, if they have to stay on there an extra month until the new ones are ready to be seated, at least they have a quorum. I'll entertain any questions. If not, I'm moving passage of the morning roll call.
Questions? We have questions. Senator Hobson, for what purpose you seek recognition?
Question, Mr.
Will you
President.
yield for a question, Senator?
Yes, sir.
Please proceed, Senator Hobson.
Thank you, Mr. President. Thank you, Mr. Chairman. Do you think this would be a good idea for all boards and commissions?
Well, quite possibly, because it's a problem basically every 4 years. I can tell you now, in 3 years from now, whoever the new governor is and the new local county boards of supervisors, when they place these folks on the board, sometimes it takes at least a month for them to have everything in place to go sit on that board. And they had a problem where they had to cancel some meetings because they just didn't have a quorum. Council says it's probably the common law anyway.
Yeah, there's some AG's opinions that are out there now saying that you cannot serve past your term. And I think this could resolve some other problems if we created a law, we expanded this to go to some other areas. There may be one exception in the code that can be a holdover, but I'm not even positive there is one. But I know it's common that if once you finish your term, you're out. Now, I guess the next part of it is, could we ensure that a holdover could continue under their bond or whatever insurance would be required to protect them and that board if they make a decision after their term?
Yeah, and that's one of the purposes of the bill, because while we're waiting on the new appointees to receive their bond, you're probably got a month lapse in there where they're meeting twice a month, and they don't have enough people for a quorum.
No, I'm with you. I'm agreeing with you that maybe this is something we need to do for all boards and commissions. And I don't know if this bill, if it would be germane, and I haven't thought through all the mechanics, but the 2 things that pop in my mind are, number one, the insurance that would be required, so that if they vote, the holdover votes in the next term, they haven't exposed themselves personally or exposed the board by not being reappointed. And number 2 would be to their bonds continue, which is the same essentially, that, protection of the entire board and themselves. So do we?
Quite possibly could be a deal where the bond would take place as long as they're needed on that board or until they're replaced. There's definitely some options. We certainly have time for that, because I just don't think that this is going to really kick in until 3 years from now. You're going to have the same problem again.
Yeah, I understand, and I'm just thinking aloud here that if you had a new regime, a city regime or county or in the state that took place, they might want to replace, part of the reason they may have been elected was to replace a board. And would it be that, of course, they'd have to act pretty fast to get this person replaced. Would there be any downside that you can think of for allowing that person in a previous board on a previous regime, municipality, city, county, whatever, to continue to hold over?
Yeah, the purpose is to continue business, and this is appointments to any county, port, and harbor commission shall hold over until their successor is appointed, sworn in as a member, or related purposes.
You wouldn't be opposed if we might find, if this is the vehicle or some other vehicle, to extend that for all agencies and boards and commissions throughout the state?
I think that'd be okay.
Okay, we'll let this one roll, but I may see if we can look at this as a vehicle for doing it for a lot of other boards and commissions. Thank you, Senator Moran.
Absolutely.
Thank you,
Any
Senator
other questions?
Any other questions?
Not, I move for passage of morning roll call.
Senator moves for passage on morning roll call. Does anyone object to the procedure? Anyone wish to record voting no? Present.
Thank you, Mr. President.
Bill passes pursuant to the morning roll call. Items 61 and 62 retain their place on the calendar. Chairman Bryan. Chairman Bryan.
I would ask that we pass items 63, 64, 65, and let them retain their place on the calendar. And I would go to item 66 and ask that the title be read.
63, 64, and 65 retain their place on the calendar. Mr. Clerk, please read 66. Senate Bill 2759.
Number 2759, temporary assistance for needy families, increase the monthly amount.
You're
I make the
recognized.
usual motion.
Senator makes the usual motion. All in favor signify by saying aye. All
Aye.
opposed, no. The ayes have it. Senator, please proceed.
I move that the committee substitute be considered in lieu of the original bill.
Please explain committee substitute. You're recognized, explains committee substitute.
Mr. President, as I look to my right, I see someone and I recognize him. He's Senator Fillingane, and I would ask the chair also to recognize Senator Fillingane.
Senator Fillingane, you're recognized to explain the substitute.
Thank you, Mr. President, and thank you, Mr. Chairman. The committee substitute for Senate Bill 2759 is a request from our Department of Human Services, and Mississippi has not increased its monthly benefits for the temporary assistance for needy families in some 21 years. The legislation before you proposes raising that monthly benefit amount by $90 per month. And so to let you know what that translates into for a family of two, they currently receive $146 a month. So that increase would bring that monthly amount for a family of two to $236 per month. For a family of three, current amount is $170. The new amount would be $260. And then for a family of four, they currently receive $194, and this increase would bring it to around $284 per month. So we're not talking about a lot of money. These are the poorest of the poor in our state, and the proposed change will result in a redirection of approximately $2.8 million being paid out in TANF basic assistance monthly benefits to assist families recovering from the pandemic and other reasons. So these are 100% federal dollars, so you're not talking about state matches or state dollars here. The funds are at the Department of Human Services, and when asked if this would cause any disruption in services from other subgrants, Mr. Anderson, the director, says no, that they have this money available. Again, it's federal money. They get a block grant of around $86 million per year, and this 2.8 would come out of that block grant that they already have. So that is a basic explanation of the committee substitute. I'll be happy to answer any questions.
Senator Hill, for what purpose you seek recognition?
Question, please.
Senator Yu for question.
Sure.
I was trying to look through there to see if there was anything deleted or added in the bill, and I did not see anything. But my question would be, is there any change in the requirements or what somebody has to submit to qualify to the Department of Human Services? Is there any changes, anything waived or flexed for that? It's just the increased amount?
Just the increased amount of this bill, yes, ma'am.
Okay, thank you.
Thanks.
Senator Turner, for what purpose you seek recognition?
Question.
Will you yield for a question, please?
Yes, sir.
Please proceed.
Thank you, Mr. President. Senator, how do we determine or go about figuring what these increases would be?
I'm sorry, I couldn't.
How do we determine the amount for the increases?
Oh, okay, I asked that question as well, and Mr. Anderson, the Director Anderson of the Department of Human Services said that when he took over, he was aware that no increases have been done in over 20 years, 21 years to be exact. So for the past 21 years, the amount of TANF funds for poor families in Mississippi has been static. And again, the numbers were, as I said earlier, a family of two currently receives $146 per month. So again, that's, and I don't know about your budget or mine, but that's not a lot of money for a family of two for a whole month. Of course, there are other benefits they may be entitled to as well, SNAP benefits and things of that nature. This is just the TANF benefit amount that I'm talking about here, but that has been static for 21 years. So when Mr. Anderson was appointed, came in and looked at the amount of monies that they had from the block grant they get from the federal government each year, he calculated that a modest increase of $90 per month in each of these categories was certainly something that, given the monies they had available in the fund right now, that they could do. And I said, well, can we do more? You know, obviously. And he said, no, there are other sub-grants that have already been awarded that go out for other purposes. And if we went any beyond, he felt like the $90 per month, then it would start bumping into other services that DHS provides. As you probably know, about a third of the block grant that they get every year is immediately shaved off and given to the child protection services. Those agencies used to be one, and now they're separated by law. So of the $86 million they get, immediately a third of that, or approximately $28.6 million, is diverted immediately to child protection services. So they're left with, the 2/3, approximately $60-something million. And so there are approximately 3,000 families that qualify right now in Mississippi for these funds. Of course, that changes every day. People can drop off of that list based on qualifications, or they can be added to the list. But when I asked him, how many families we dealing with here, he says it ranges usually from about 2,500 to 3,000 families, and it's closer to the 3,000 mark right now. But of course, that's, that increases and decreases as time goes on.
Of the funds that are being used that would be used to fund these grants, does part of this consist of any CARES Act dollars?
These are not CARES Act dollars, no ma'am. These are strictly Medicaid funds that Mississippi gets, Department of Human Services gets in a block grant each year. And if those monies aren't all spent in one year, they do roll over from year to year. So it's not like if you don't use it all, it reverts back to the federal government. It just rolls over to next year's budget. So you're not going to lose the money if you don't spend it all. It'll still be there next year. But he felt like that $90 in 21 years with no change, that this was a modest but reasonable amount that Mississippi could afford. Again, this doesn't impact any state dollars. These are all federal dollars. But if you take too many, then you do start impacting other programs that they operate. So it's not like they're just, millions and millions of dollars just sitting there not doing anything. That's the reason he wanted to be careful, he told me, with the amount that he's requesting for the increase. But $90 per month is what he felt like would be the kind of the sweet spot, the right amount, which is a significant bump, but not too much that's going to jeopardize other programs.
And this block grant that we receive, is it a static amount from year to year, or does it change?
I think it does change. It's around $86 million. It grows over time. It's based on your poverty level, obviously. So as more people get jobs and drop off of the poverty, amounts, then of course that money can go down. Or if in the middle of a pandemic, people lose jobs, more people, fall below the poverty line, those dollars can increase. So it's sort of a function of the amount of poverty in any state at any given time.
And is it only DHS that monitors these funds to determine if there's going to be an increase? Is there any other body within the state that looks at these numbers?
Other than the legislature, obviously we have oversight over the agencies through the legislation like this that we present, but they are the administering body for the state when it comes to these types of funds from the federal government.
Thank you.
Thank you.
Thank you, Senator Turner. Senator Sojourner, for what purpose you seek recognition?
Question, Mr.
You for a
President.
question, please?
Yes, sir.
Please proceed.
Thank you, Mr. Chairman. So this would be an increase on welfare benefits received?
Yes, ma'am. Absolutely.
And it would be an increase to individuals that are already receiving benefits?
That's correct.
And also to new individuals applying for benefits?
If they qualify. This doesn't, as I told Senator Hill earlier, there's no change in the qualifying requirements in this bill. This simply says if you qualify under our current requirements, instead of receiving, the amount that you were, you're going to get $90 more per month.
Okay. And I know that you mentioned this doesn't deal with state dollars, it's federal dollars. Of course, those are all our dollars.
Amen. They're all tax dollars.
And I know that it would be a range, but about what is the range of total dollars that this new increase would cost?
A $2.8 million increase.
Okay. Thank you.
Thank you.
Thank you, Senator Sojourner. Senator Parker, for what purpose you seek recognition?
Question, Mr. President.
We yield for a question,
Yes,
Senator.
sir.
Please proceed, Senator Parker.
Thank you, Mr. Chairman, for your work on this, and I do believe, as you do, that an increase can definitely help in this situation. Do you remember in the committee meeting, the discussion on the reserve amount that was remaining in the TANF fund after this? Do you remember what those figures were?
I remember you asking the question. I believe the answer was around $16 million, maybe.
Right. I think you're correct on that. I believe in the discussion, we were talking about the fund having somewhere close to 20 million and the 2.8 million,
Right.
bringing that down in the 16 to 7,
Yes, sir.
$17 million range. And after that, I have been trying to at least figure a way where we as a legislature can maybe utilize that more. And I have not found a way yet to do that. But you mentioned grants and block grants and other things in your discussion. Are there perhaps some things that the DHS can apply for that they have not been applying for that could actually further supplement what their department needs are?
I think that's very possible. And of course, these laws, like we change and meet the state laws every year. The federal Congress and Senate meet and change the rules every year and add more money. There may be some COVID relief dollars that will flow to the states here shortly. Who knows? But I think you're right. I think this changes year to year, and I'm certainly in favor of doing what you're talking about, because especially in the middle of the pandemic, when people are losing jobs that were working and through no fault of their own, they'll find themselves without work, there are real needs out there, and some of that includes food.
Right. And I'm just hopeful that DHS can find a way to provide some resource and some funding for that, because we do have some needs this year that I believe many of us feel need to be addressed. And each time I hear a discussion on this, I feel like there is some resource availability there that maybe has not been tapped yet. But thank you for your work on this.
I would not disagree with you, and thanks for your work.
Thank you very much. Senator McDaniel, for what purpose? Senator McDaniel is good. Okay, anyone else? Any other questions? Any other questions? All right, Senator, we're ready for your motion.
Thank you, Mr. President. I would move adoption of the committee substitute in lieu of the original bill.
Motion is to adopt the committee substitute. All in favor signify by saying aye.
Aye.
All opposed, no. The ayes have it. You're ready on the
Move
motion.
adoption, or suggest adoption based on the morning roll call, Mr.
Some
President.
more roll call has been requested. Anyone object to the procedure? Anyone wish to record as voting no? No. Sojourner, no. McDaniel, no. McMahon, no. Anyone else? Chisholm, no. Chisholm, no. Williams, no. Seymour, no. Tate, no. Anyone else? Anyone? Hill, no. Anyone else? Okay, Ms. Clerk, would you please read? Barrett's no. Barrett's no. Would you read the names, please?
Voting no or nay, Sojourner, McDaniel, Hill, McMahon, Chisholm, Williams, Seymour, Tate, and Barrett.
Bill passes with the noes as recorded. The bill passes. We'll move on back to the actual. We have a question, Senator Simmons. For what purpose do you seek recognition?
Thank you, Mr. President. With unanimous consent, I ask to be added as a co-author to item number 66 on today's calendar, Senate Bill 2759.
2759. Senator Simmons, would you please read the title of the bill, Mr. Clerk?
Senate Bill number 2759, temporary assistance for needy families, increase the monthly amount.
Thank you. Senator Simmons? Senator Terry? Thomas? Barnett? Simmons? Jackson?
Sampson.
Jordan? Frazier?
Norwood.
Norwood, behind us here. Turner, Ford. Butler. Sampson, Jackson, I believe you got it. Please, ma'am. Blunt. Jackson. R. Robert. Anyone else? Anyone else? Okay. Seeing no objection, granted, motion's granted. Back to the calendar 67, Senator Bryan,
I ask that the title be read.
please read the title.
Senate Bill number 2762, Department of Human Services, permit use of a simplified reporting system.
I make the usual motion.
Senator makes the usual motion. All those in favor signify by saying aye.
Aye.
All opposed, no. The ayes have it. Please proceed, Senator.
Mr. President, this bill and the preceding bill were bills that were recommended to us by Mr. Anderson, who is the new head of the Department of Human Services. I think we're very fortunate to have Mr. Anderson there. He's certainly got his hands full, and I think he's making an extraordinary amount of progress in a very short amount of time, given the difficulties which he found when he walked in the door. So for myself, I'm very much inclined to agree to support recommendations from Mr. Anderson. Having said that, I would ask the chair to recognize Senator Fillingane, who would explain this bill.
Senator Fillingane, you are recognized to explain the bill.
Thank you, Mr. President. Thank you, Mr. Chairman. Senate Bill 2762, as you can see, is a very short bill. It basically makes one change, and the current law requires Department of Human Services to transition to what's called a change reporting for eligibility reporting purposes for the agency's economic assistance programs. DHS formerly has operated using what's called simplified reporting. And the difference roughly, as I understand, the difference is in the current regimen of what they do, they have to go out and visit annually with each and every recipient on an annual basis, sort of an individualized, every person has to be contacted to make sure he or she still qualifies for these benefits. And, I supported that when we passed it. It makes sense, it sounds good. In actuality and in practice, it has really run the error rate up well beyond what the federal government allows without you losing federal monies for these programs. Our current error rate using the system that we're using now is 9.4%, meaning that when you check, there's about 9.4% of the folks out there that are either being denied benefits that should be getting benefits or vice versa. They should have gotten benefits and they didn't. And so the federal government only allows for a 6% error rate, and if you go above that 6% error rate, which we currently are, by about 3.4%, then you begin losing money. So what Mr. Anderson, the director, says, this liability, if not corrected, this error, in other words, if not corrected, could result in a penalty assessed to the state of Mississippi of almost $200 million. So instead of saving the state money, which is what we all were trying to do when we made this change, this reporting has actually created an insurmountable administrative burden on the agency and could begin causing us to lose quite a bit of money that we either have to replenish ourselves or the folks just wouldn't get the benefit. So change reporting requires DHS to recertify SNAP cases every 6 months instead of annually. Under simplified reporting, DHS recertifies SNAP cases annually, as I said earlier. Only one other state, the state of Maine, currently uses the system that we're using, and they are also considering a return from change to a simplified reporting system. So this is what it proposes to do, and I'll be happy to answer any questions.
Questions on the bill? Senator McDaniel, for what purpose do you seek recognition?
Question, Mr. President.
Will you yield for a question, Senator?
Yes, sir.
Please proceed.
Thank you, Mr. President. Mr. Chairman, it's after lunch, small bill.
Simple bill.
Simple bill, but a pretty big impact.
Absolutely.
I want to ask you a few questions about that.
Go for it.
And by the way, you and I see eye to eye 99% of the time on these things. Maybe we disagree on this. This was by request by the agency, right?
This is, yes.
Okay, the agency wants us to change certain determinations that we presently get to make. And as I understand the law, the federal government gives us some discretion as to how we determine who is actually eligible for these benefits, correct?
That's correct.
And it gives us a couple of options. One of the options is called the change option, and the other is called the simplification or the simple option.
Right.
Under the change option, this is something that's very important. they have a reporting responsibility. That is, the recipients have a reporting responsibility whenever their income changes more than $100 under the change option. When that occurs, they have to pick up the phone or send an email or let the department know that their circumstances have changed, correct?
That's correct.
And we implemented that back in 2017 when Governor Bryant was the governor, with the idea of putting more responsibility on these end recipients and to make sure that people who are receiving the benefits were the ones that actually were supposed to be receiving the benefits, right?
Right.
The idea being that if people receiving these benefits aren't supposed to be, then there's not enough money for the ones that truly deserve it.
Absolutely.
And that's why Governor Bryant wanted this legislation passed.
Right.
If we change this and we go from the change reporting requirement to the simplification requirement, our welfare rolls are going to grow substantially, are they not?
It certainly has a potential for adding more people to the welfare rolls.
Most of the economists that have looked at this have indicated that if we take this change right now, our welfare rolls will explode. If that occurs, more federal money will have to be utilized, more state money will have to be utilized. And my concern is that we're going to have to pay for that over the long run. You would agree with that, correct?
That is certainly a possibility. The question, I think, would become, if the rolls grow, are those people that deserve the benefits and just were formerly not on the rolls and they should have been on the rolls, or are these people that ought not to be on the rolls that we just miss and they get on there by mistake?
Right. You mentioned, I think the department, one of their concerns is this reporting error rate, or I think that's what he said.
Yes.
And his position is, or their position is that if it reaches a certain level, then naturally there's going to be some punitive action taken by the executive, federal executive.
Correct.
Or the federal government.
Yes.
Here's the thing though, the reason the error rate is as high as it is because the change program is actually working. And I think that's what the commissioner or the agency head may be missing here, is that the error rate is increasing because what Governor Bryant implemented is working. You would agree with that, wouldn't you?
I don't look at it that way, but I rarely try to disagree with you, Senator McDaniel.
You're very kind. Mr. President, I'd like to speak on this bill at the proper time.
Thank you, Senator McDaniel. Other questions? Other questions? Senator England, for what purpose you seek recognition?
Question, Mr. President.
Were you here for a question,
Yes,
Senator?
sir. I
Please
do.
proceed.
Yes. Thank you, Chairman Filligan. My question is, and I'm trying to better understand this, is the current reporting system causing the error, or is there a current reporting system identifying the error rate that we have?
And I think that depends on whether you look at the glass as half full or half empty. I think it's a matter of perspective, clearly. I think rational, reasonable people can differ on, is it a cause or an effect? But I do know that if the error rate, regardless of the reason for it, remains at this elevated level that it's currently at 9.4%, which is our current error rate, then we stand to lose $200 million. The federal government has already put DHS on notice that the error rate is unacceptable. Anything over 6% is dangerous in their opinion and can lead to a loss of funds. And I will also say that there is a 3-strike penalty for this non-reporting. The first penalty, you can be suspended your benefits. The second one, another suspension. And the third, you are permanently disqualified. So for people that are trying to game the system, there is sort of a 3 strikes and you're out situation. So there is a very serious consequence if you're found to be misreporting.
Is it the thought of this agency that if we go back to the old reporting system that our error rate will go down?
That 48 states are using, yes. And that we previously used, we've tried the new method, our error rate skyrocketed, and now we in Maine, which, I've been to Maine, it's a lovely place, great syrup, but we don't have a lot in common with the state of Maine otherwise than this particular reporting method that we're using. So I think all the other 48 states, some of whom have tried this system, have now gone back to the simplified reporting.
And I understand that. I understand the reason behind that because of federal money, but I'm just worried that we're working under a system right now where we're actually identifying errors and can maybe correct those, which was probably the purpose that this body put that into place in the first place. And now that we've realized that there are results that we needed to be looking into anyways. Instead of looking at the actual issue, we're going to go back and change back to the old reporting system so that our error rate is lower. Is that correct?
Could be. I mean, obviously, the other method, you sample. You basically, it's like a polling. You know, when you take a poll, you don't poll everybody in the state of Mississippi to figure out who's going to win the next governor's race. You do a sampling. I mean, you sample a representative number across the state, usually 400 or 500 sample voters, and you get an outcome. It may not be exact, but in most cases, if they're a quality polling operation, they're pretty close. Same idea here. You sample a number of people that are on the program to see if, in fact, they are reporting accurately or if they're not. And that is the mechanism by which the other 48 states try to monitor who's getting the benefits and whether they ought to or not.
Yeah, thank you, Chairman Filligan. And I do like the analogy of the polling, because I've learned watching polls that a lot of times the pollsters can ask the questions in a way to get the results they want. And
Exactly.
I'm worried that we're changing the questions here rather than actually addressing the issue with our system. But I appreciate you answering my question.
Thanks for your question.
Thank you. Senator Hill. Senator Hill's button is on. One moment, please.
I yield.
Senator, will you yield for a question?
Yes, sir.
Senator Fillingham, I'm looking at an article published August 12, 2019, that says, according to the numbers released by the U.S. Department of Agriculture, the Mississippi Department of Human Services has the 4th lowest payment error rate nationally with the SNAP program. So my question is, if we went from 2.9, let's see, what did it say it was? 2.43% on overpayments and 0.49%. So the total error rate was 2.92 in 2019, according to the numbers released by the Department of Human Services, Department of Agriculture. How did we get from the lowest, 4th lowest error rate in 2019 to 9 point something now, and this new system was put in 2014?
Well, I think part of the problem may be the fact that you had in this particular regime, if you will, you had people allegedly paying pro wrestlers for things that they ought not to have been paying them for. You had millions and millions of dollars flowing into pockets of people allegedly the money shouldn't be flowing to. So I don't know that I would look at the former head of DHS as sort of the gold standard by which we ought to judge the outcomes that they were reporting at that time.
I'm not looking at it at the gold standard. What I'm looking at is we didn't have hardly anybody even getting that back then, because it was all going to those grants. So there was hardly anybody to audit. So if it's 9 point something% now, and we're trying to do it right, maybe that's a good reflection and not a bad reflection, because they're saying we weren't servicing anybody back then.
Or possible, or it could be a further proof that there was something going very amiss at the Department of Human Services for a number of years that is now just being discovered.
And I'm also seeing that 27 other states still use the change reporting system, so we got some discrepancies going on, and I don't know which information is good and which is not, but I'm
Well, I'm
finding...
getting my information from the current director of the Department of Human Services.
I'm not questioning your integrity at all, don't think that. I'm just saying I'm finding discrepancies across some of the data that I'm seeing.
I appreciate it.
Thank you.
Thanks.
Other questions? Senator McDaniel, for what purpose you seek recognition?
One more question, Mr. President.
Yes, Senator.
Certainly.
Let's go.
Senator Finnegan, just to help my feelings a little bit, and I think a few of us, would you be willing to put a reverse repealer in this so we could work on it some?
I have no objection to that, but I am not the chairman of this committee either, so I certainly don't want to speak for Senator Bryan.
All right, well, I'd like to make since there are no objections, I'd like to add an amendment if possible, Mr. President.
Certainly. If you file with the clerk, we'll bring it up. Other questions? Other questions? I think, Senator, first we have to go to whether or not to pass a bill, and then we will look at an amendment. We're ready for your motion, Senator.
Okay, thank you, Mr. President. Well, this is not a committee substitute, so I think the motion...
All right, Senator McDaniel, you're recognized.
Thank you, Mr. President. All the amendment would do was to add a reverse repealer. That's all it does. I'd appreciate your support.
Senator Bryan, would you like to speak on the bill? On the amendment, I'm sorry. You're speaking on the amendment. Senator Bryan.
I don't object to the amendment if that's what the Senate wants to do. But I am somewhat taken aback by the response of the Senate to this proposition. I believe this morning we had a situation with a big corporation who made a mistake in its paperwork. They've got lots of expertise. They've got lots of money. They've got lots of lawyers. They've got lots of accountants. They've got consultants. They've got all of this. And with all of that oomph, they made a mistake in their paperwork. And the mistake cost them, I'm guessing, millions of dollars. And so this legislature is going to pass a law that says basically they won't be punished for their mistake. I think it passed unanimously. We're dealing with the poorest of the poor in this state. We're dealing with people who, as a group, are not all that sophisticated. And somehow we put into the law a requirement that they have all manner of reporting obligations. And under the existing law that we have, if there's a mistake made in their reporting obligations and on, it goes into our error rate, and the head of the agency is telling us that makes it unworkable. And we're getting penalized. And we're going to get penalized. We're going to get penalized far, 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 far more than the amount of money that we're talking about here. And so the head of the agency, who was appointed by Governor Reeves, says it's a technical matter. We need to make this technical change to the law so that we, the state of Mississippi, will not be punishing ourselves by requiring voluminous reporting on the part of individuals who are relatively unsophisticated. I don't object to the reverse repealer, but I do think we need to focus on what's really going on. I'll just give you one example of something that happened to a constituent of mine. And this is the sort of thing we're talking about. There was, our constituent had food stamps. I don't know this directly. I've been told this. I haven't investigated, but I've no reason to question any of this. There was an individual who was selling quantities of meat in packages and would come around and sell that meat, and this food stamp recipient would buy large quantities of meat there because it was relatively inexpensive. The individual who was selling the meat showed up on one of the systems that they have to determine fraud because there were a number of even dollar amounts. Well, I mean, that's a fine thing. You look at a bunch of even dollar amounts, you wonder, are people coming to get cash? But as it developed, all of his prices were at even dollar amounts. So there was a reasonable explanation. Fine to investigate, there's an explanation, so much. Looking into his dealings, however, they found some mistakes that he was making about food stamps. But he should have known what he was doing. When my constituent went to get food stamps, the guy who was running this thing told her she had to pay him $10 for a fee to get her EBT card set up. And she paid him a $10 fee as she was told by him to do. As a result of that, she had violated the rules because you can't pay somebody a fee to get your EBT card. And she'd been notified of this. She actually had notified that that was against the rule. She was notified in a stack of paper this thick, just on and on and on and on and on. That's how she got notification that she wasn't to pay the $10. So she was denied food stamps. Fortunately, she was able to get that fixed. She could get her food stamps again. But that is the sort of minuscule issues with which we're dealing. We're dealing with the poorest of the poor people in the state, and we're dealing with people who generally are unsophisticated. The head of the agency appointed by Governor Reeves tells us it's a technical matter. The legislation we passed several years back is creating far more difficulty than any good that it's doing. I believe the error rates that were quoted, it being low, I don't know, but my surmise is those are error rates for years prior to the adoption of this system. There's a lag in the time from which the year that something happens and the year it's reported. That's my surmise. I don't have an opinion one way or another about a reverse repealer, but I think we need to focus on what we're really talking about and what we really mean when you talk about an error rate.
Thank you, Senator Bryan. Senator McDaniel, you're recognized to respond on the amendment.
Mr. President, since there's no opposition to the reverse repealer, I'll save my comments when I'm able to speak on the bill. So at this stage, I would just ask that the Senate adopt the reverse repealer.
Seeing no further questions, we have a motion. All in favor signify by saying aye. Opposed, no. Let's go back. Chair's in doubt. All those in favor signify by saying aye. Aye. Opposed, no. Noes have it. Proceed for, pardon me? Division. Mr. Secretary. One moment while everybody returns.
Should we say if they're out there, they need to come into the chamber where we can see them?
I will. I'd ask Senator Fraser, if there's anyone behind me, would you please ask them to come to where they can be visual? If y'all would socially distance, but get where I can see you one way or another. Okay, we'll go. All those in favor of the amendment, please stand. I get 23.
23. I think somebody stood up after I went by.
Okay. Please be seated. All those opposed, please rise.
Do we need to recap?
22, there's 23, 22.
22 to 23.
What?
23 to 22.
That's what I'm saying. The bill passes.
The amendment's adopted.
Yeah, it's close. By a vote of 23 to 22, the amendment is adopted. Back on the bill.
Thank you, Mr. President. I would suggest adoption by use of the morning roll call.
You want to speak on the bill?
Oh, sorry.
Senator McDaniel speaks on the bill. Back on the bill.
If you'll indulge me just for a couple of minutes, and I want to try to explain why this bill is a bigger deal than it appears. It's one page that changes an awful lot. In 2017, we worked diligently with Phil Bryant as our governor to make sure that we were trying to find problems with the system to root out fraud, waste, and abuse. Well, how do you root out fraud, waste, and abuse if you cover your eyes and don't attempt to find the fraud, waste, or abuse? So the idea is to change the way we ask enrollees to provide us information. Here's the idea, and it's really quite simple. Senator Bryant spoke about a sophisticated or an unsophisticated enrollee. Under the change system, if their resources or finances increase more than $100, they have a responsibility to call, to contact, and to provide information to the department. The reason for that is simple. If they make enough money, if their resources change for whatever reason, perhaps an inheritance, perhaps a new job, whatever the case may be, they would not be entitled to benefits. Under this change, now listen to this for a moment because we're talking about sophisticated or unsophisticated end users here. If we change it back to the old way, they're going to have to anticipate what 130% of the federal poverty line is. Can anybody in here tell me right now 130% of the FPL? And we're supposed to be the sophisticated ones. So you think that unsophisticated enrollee can anticipate the changes that are made yearly, calculate those changes made yearly, then report to a state willing to listen? They cannot, not accurately. And so what occurs here, an honor system is created, but it's flawed because the state's eyes are closed. We're not watching for error, we're not watching for fraud, we're not watching for waste or abuse, and so inevitably it happens. And guess what? That error rate, Senator England, it drops. Do you know why the error rate drops? Because we're not able to catch it. The error rate isn't necessarily a bad thing. We're trying to find problems in the system. So when the rate goes up, that just means the system worked at that moment. The answer is not to eliminate that issue. The answer is to provide more enrollee information. They should provide the information. Our taxpayers deserve that. Because Lord knows, we want to make sure the people who deserve this help are getting it. But the people that don't deserve it, they don't deserve a single dime of taxpayer money. And that's the system. But that's what this bill does. It reverts to the old ways, more fraud, more waste, abuse, and yes, conclusively, without any question, it will expand. No, it will explode our welfare rolls. Tell that to the taxpayers that I represent. That's what this bill does. So if you wonder about my frustration, that's all it is. And Senator Fillingham, it's certainly not at you because you and I are like this, right? You're still my friend? Absolutely. But the bill, in my mind, is not a good bill for this body. I would ask you to vote no.
Senator Bryan would like to speak on the bill. Senator Bryan, you're recognized. I'm sorry, Senator Hobson, a question beforehand.
Question for Senator McDaniel.
Okay, Senator McDaniel,
Yes,
you're here
sir.
for a question.
I do.
Please proceed.
Thank you, Mr. President. Thank you, Senator McDaniel. Did you attend the Public Health Committee meeting when Director Anderson made his presentation on this?
I did not attend it. I'm not a member of Public Health.
Okay. Are you aware that he said that we're the only state in the country that uses the antiquated system that's being used right now in Mississippi?
I am aware of that. I'm also aware that 26 other states have an option. In other words, they still utilize the change system to some effect. So I am aware of that data.
Did you hear his report about the high error rate that we have in Mississippi? You heard that, didn't you?
Oh, I understand. I know why it exists as well. It's because the system is working.
And I heard your explanation, and I voted with you on the amendment to put in the reverse repealer because I don't mind keeping this alive to study it. But are you aware that if we kill this bill and we're hit with a penalty from the federal government, you could cost the state, I think it was $196 million?
The penalty is a result of improper payments. One would think our system would be created to deter improper payments, right? And so what I'm hearing there is, let's just close our eyes to the possibility of improper payments because we could be penalized on the back end. And my position there is that it's still taxpayer money. I mean, we get caught up in this situation where we think the state of Mississippi is somehow saving money. The taxpayer is still the taxpayer, and a federal burden is just as powerful as a state burden. And so that $190 million is still money we have to expend, is it not?
No, absolutely. I'm going to ask you, is the punishment for what we may do with an antiquated system worth, if we save $3 million by catching some that aren't filing out their forms properly or that are doing, I agree wholeheartedly with you. If somebody's committing fraud, they need to be prosecuted. But if we save $3 million and cost ourselves $196 million, do you think that's a good exchange for the state of Mississippi?
If we were in court, I would object because that's a false choice, right? And here's why I say that. The assumption underlying your question is that we can't find a way to reduce the improper payment rate under the change system. And I believe we can.
Okay, look, like I said a minute ago, I voted with you. I voted with you on the amendment because I'm willing to keep this bill alive because I want to find out what the answers are to those questions. So if you kill it right now, you're guaranteeing the potential to cost the state roughly $200 million. If you keep the bill alive, you got a chance to look at the systems before you discount the other systems that may be out there and the other types of programs that may be available here. You're going to kill every chance there is to make sure that the state's using the best system that'll do both what you say, and I agree, is to stop fraud in our system, but also to make sure that we don't get hit with a penalty from the federal government that's going to cost us hundreds of millions of dollars.
Not a chance. If the department understands the ramifications of the high error rate, they'll take other justifications and other reasons. They'll correct it. They don't have to keep going down this path, and we don't have to ignore the error. It can be corrected without changing the method by which the reporting takes place.
So you're not willing to continue to look at the bill so we can keep this alive a little bit longer to make sure that we've got everything in place before we take a chance, because once we pass up this opportunity, this may be the only chance we have this year to deal with this measure.
And that is a compelling argument, and my response to that would be, if this bill makes it through, Terry Brown once told me years ago, he says, if you see a snake on the floor, you kill it. And I'll believe in that. Now, I don't mind discussing these bills, but the answer here is clear. It will expand our roles. And the idea that we have to turn a blind eye to the idea that the commission or the agency can't correct these issues without changing the way it enrolled its report, that seems a bit naive to me. But I hear you, and that's a compelling position. I'll admit that, yes.
Okay, thank you.
You're right.
Thank you, Senator Hobson. Senator Bryan, you're recognized to speak on the bill.
All the bill does is give discretion to the head of the agency to adopt the system that he feels is in the best interest of the state and in the best interest of the agents. It doesn't require anything. It just gives that minuscule amount of discretion to the agency head.
Thank you, Senator Bryan. Any other questions? Anyone want to speak on the bill? Seeing none, we're on the bill. Senator Fillingham, you're recognized for your motion.
Thank you, Mr. President. I would move adoption by use of the morning roll call.
Adoption by use of the morning roll call has been requested. Anyone object to the procedure? Anyone wish to be recorded as voting no? No. McDaniel. Sojourner. Chisholm. Williams. Hill. Anyone else? Anyone else? Seeing none, bill passes with those voting no. We'll go, Chairman Fillingham, we're on item 68, please, sir.
Thank you, Mr. President. If we could skip item 68 and let it retain its place on the calendar and go to item number 69, please, sir.
68 retains its place on the calendar. 69, we're ready, Senator.
Thank you. I move that we call it up and have the title read, please.
Mr. Clerk, please read the title.
17, juvenile offenders provide alternative sentencing and parole options.
I make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye.
Aye.
All opposed, no. The ayes have it.
And I move that we move to the committee substitute and adopt it in lieu of the original bill. And if you would recognize Senator Thompson to explain the committee sub, please.
Senator Thompson is recognized to explain the committee sub.
Thank you, Mr. President. Thank you, Mr. Chairman. That's a tough act to follow. But this is this bill is equally important. This is Senate Bill 2117 is going to modify our state's sentencing guidelines for juvenile offenders to bring them in line with Supreme Court precedent under Miller versus Alabama and several other cases. And so I just want to take a few moments to walk through this bill and explain to the body what we're trying to do here. Currently, Mississippi law only provides one standard for murder convictions, and it does not distinguish between juvenile or adult offenders. And in Miller, and it allows for sentencing of life in prison without the possibility of parole. Under Miller, the Supreme Court says for juvenile offenders, you cannot convict them or you cannot sentence them to life in prison without the possibility of parole, without having a separate hearing by the judge to meet certain factors that are enumerated in Miller. So in the first section of the bill, we're going to revise 97-321 and provide for sentencing for juvenile offenders who are defined as persons who are under the age of 18 at the time of the commission of the offense. In the second section of the bill, in section 2, we're going to revise 99-19-101, which is upon the conviction or taking a guilty plea of a defendant of capital murder, that a sentence of death cannot be imposed if the defendant was not at least 18 years of age at the time. And then if the defendant was under the age of 18 at the time, then subsection 9, which is on lines 185 and below, provides for the Miller hearing where the judge himself, without a jury present, will hear from the defendant and determine whether or not that defendant is eligible for life without parole. That's an explanation of the bill, and I'd be happy to take any questions.
Questions on the bill? Questions on the bill? Senator Hill, you're recognized for a question.
Thank you.
Yes,
You yield?
yes, ma'am.
Is this the one that was in committee that was in result of some court directive, or where did this come from? I'm trying to remember, I get these things confused.
I don't know that this one, when you say some court directive,
Did this one come out of Judd A or Judd B?
it came out of Judd B, ma'am.
Pardon?
Judiciary B.
B. I thought I remembered this one, so basically what was the impetus of the bill, if you can remember? What was the reasoning for the bill?
Well, because right now Mississippi's current sentencing guidelines does not distinguish between juvenile and adult offenders for murder. So under our current sentencing guidelines, juvenile offenders can be sentenced to life without the possibility of parole. The U.S. Supreme Court says you can't do that. A juvenile cannot be sentenced to life without the possibility of parole. So we're trying to revise our sentencing guidelines to bring in line with Miller and about 3 or 4 other cases that address juvenile sentencing. And to that point, Senator Hill, what this does is the current statute, the current structure, just creates a basis for appeal. It creates a basis for appeal.
Thank you, Senator. Senator Wiggins, for what purpose you seek recognition?
Friendly question.
Will you yield, Senator?
Yes.
Please proceed.
Yeah, just to build on what Senator Hill said, this is a result of the U.S. Supreme Court in Miller declaring the death penalty unconstitutional for those under 18. Is that right?
Death and life in prison without
death and life imprisonment. And so not only Mississippi, but other states across the country, their death penalties have to be redone. And this is us attempting to do that. Is that right?
Yes, sir.
Okay. And prosecutors and criminal defense attorneys have understood that we need to do something on this. Is that right?
And judges. Yes, sir.
And judges. Thank you. Thank you.
Thank you, Senator Wiggins. Other questions on the bill? Other questions? Okay. We're ready on the substitute.
On the committee sub, I asked for adoption by the morning roll call.
Well, adoption by voice vote. All those in favor signify by saying aye.
Aye.
All opposed, no. The ayes have it. We're on the bill now, Senator.
On the bill, I asked for passage by the morning roll call.
Senator's request to pass by the use of morning roll call. Does anyone object to that procedure? Anyone wish to be recorded as voting no? No. Any present? Seeing none, the bill passes by morning roll call. We go to number 70. Senator Finnegan, you're recognized.
Thank you, Mr. President. I'd like to go to that item called up and have the title read.
Mr. Clerk, would you please read the title?
Senate Bill number 2121, intimate visual material, criminalized disclosure of.
Make the usual motion.
Senator makes the usual motion. All those in favor signify by saying aye.
Aye.
All opposed, no. The ayes have it. Please proceed, Senator.
I move that we adopt the committee substitute in lieu of the original bill and ask that you recognize Senator England to explain the committee sub.
Senator England, you're recognized to explain the substitute.
Thank you, Mr. President. Thank you, Chairman Phillingain. Ladies and gentlemen, SB 2121 is also what has been referred to around the building and around this room as the revenge porn bill. Revenge porn is generally described as being a distribution of sexually explicit images or video of individuals without permission of the image or video subject, usually to cause embarrassment or stress. This bill has been requested by prosecutors throughout this state. There are 46 other states that have laws that criminalize revenge porn. Mississippi is one of 4 that do not. This is happening here in Mississippi, and our prosecutors have asked that we provide them with a means to combat this issue. I would also note that this did pass the Senate, this revenge porn legislation in a slightly different form, a little more language in that other bill in 2019, but it did pass. Just a brief explanation of the bill. This bill would criminalize the disclosure of intimate visual material without the permission of the person depicted. This is all outlined in Section 2 of the bill. If a person discloses visual material of another person's intimate parts, exposed or engaged in sexual conduct without the effective consent of the person depicted, and with the intent to harm the depicted person. If you'll flip back to the definition portions of the bill, which is under Section 1, the intimate parts is described as meaning the naked genitals, pubic area, anus, buttocks, or female nipple of a person. The bill goes on to state that if the person has reason to believe that the material disclosed was obtained or created with the reasonable expectation of privacy, that the bill was to, that the reason for disclosure was to cause harm, and that the person being depicted, their identity is actually shown in the visual material. The reason we have a committee substitute, just to briefly let you know about that, the committee sub provides for an exemption for internet service providers. So if you just provide a platform and this material ends up, you're not liable under this bill. However, if you own the platform and you promote this material, then you would be liable. It is not an affirmative defense under this criminal law that we're creating if the person consented to the creation or even provided the material, visual material to the offender. There are a few affirmative defenses, which include lawful or common practices of sending this into law enforcement, reporting unlawful activity to anyone, and if there's a legal proceeding, the disclosure where it may be disclosed or may be permitted, disclosure may be permitted under the law. It is also an affirmative defense if the visual material was made in public or in a commercial setting with the voluntary exposure to the depicted person. So we're not outlawing pornography, we're just outlawing revenge porn with this bill. Further in Section 2, there's a long-arm statute or a long-arm portion of this statute that would allow for prosecutors to protect people in Mississippi if the actions happen within the state of Mississippi, or if a Mississippian is depicted in the materials, then the prosecutor will have jurisdiction to prosecute. A first offense under this statute is a misdemeanor. The second offense would be a felony, except if the disclosure is undertaken for the purposes of making a profit, then the first act is a felony. I would note, after taking some questions in committee, that an offender that is prosecuted under this act does not have to register as a sex offender. That is essentially the purpose and the intent of this bill. And an explanation, I would be glad to take any questions. If none, I will move that we adopt the committee substitute.
Question, Senator Simmons. For what purpose?
Friendly question, Mr. President.
Senator, will you yield?
I will yield.
Please proceed.
Thank you, Mr. President. Thank you, Senator, for yielding. Senator England, thank you for all your work on this. I raised this question in committee, but I also wanted the chamber to get the benefit of the question. Is it anything in the proposal that certifies juveniles as adults? So I guess my question goes to, in the event the conduct that is described in the bill, if it's done by minors, would it still be adjudicated in youth court?
It would, yes.
Thank you.
Thank you, Senator. Senator Horn, for what purpose you seek recognition?
Question.
A question, will you yield, Senator?
I will yield.
Please proceed, Senator Horn.
Thank you, Mr. President, and thank you, Senator England. Now, this long arm provision, is the person held harmless if they have a long arm?
I'm not sure what the prosecutors would do with regard to the measurement of a person's long arm, but they will be able to reach out legally and grab the offender into the jurisdiction.
This is like the long arm of the law.
That's correct. This is the long arm of the law, not the long arm of the offender.
Okay.
The size of the offender's arms don't matter.
That. But to Senator Simmons' question, this is serious.
Okay.
So, what if persons under the age of 18 are guilty of sending revenge pictures or video out to embarrass or to bring stress to another person under the age of 18?
I'm sorry, I'm not sure if I heard your question, but so if a person...
How does this impact youth, persons under the age of 18?
That's right. Well, again, the youth court would be the determination, would have the jurisdiction over a youth in these instances, which I believe is the same question that Senator Simmons had.
So, and you said also that a person who is convicted under the provisions of this statute would not have to be registered as a sex offender.
That's correct. That is not a part of the punishment requirements. It's not required.
Mm-hmm. But back to youth, if they are convicted, what are the penalties if you're under the age of 18?
I'm not sure if the penalties would be any different. This doesn't outline any different penalties for minors, but they would be under the jurisdiction of the youth courts in those matters. Again, the first offense under this section would just be a misdemeanor, and there would need to be conviction. And there's limitations. There's not a minimum limitation under that first offense portion of the law. The felony portion, if there's a second or subsequent violation, the individual, the offender, would be punished by imprisonment not exceeding 1 year or by a fine not exceeding $2,000 or both. So there's a maximum requirement on those, but no minimum requirement. And I imagine a prosecutor or any sort of counselor in a youth court setting could address those for the offender.
Okay, and if someone voluntarily and willingly sent you a video or photograph, is there the expectation of privacy at that point?
That doesn't necessarily create the expectation of privacy. I like to think of this as being within the spirit of the relationship. If someone shares an intimate photo of an intimate part with their significant other or others, they will they have an expectation of privacy. But if there's no expectation of privacy, for instance, if there's not, if I don't ask for the photo and it's just sent to me, I imagine that there was no expectation of privacy because there was never any communication back and forth in the first place.
But if I surreptitiously videoed or filmed someone, there is the expectation of privacy. And if I then send it out to friends or out on the web, on the internet, social media, then I'm in violation. Is that right?
That's right. And as a matter of fact, there's under Section 2, and I didn't mention this earlier, but I'm glad this gives me the opportunity to do this. If you even threaten to release this information, disclose intimate materials where there's been the expectation of privacy, you do so with the intent to harm, or you do so with the threatening attempt to require someone to perform a sexual act or to do some other, perform some other service, then that is also an offense under this act. And I'll take this opportunity, if you don't mind, while answering your question. There are, and this is across the nation, not just in Mississippi, but it does happen in Mississippi, where we have human trafficking issues. If you're a victim of human trafficking, a lot of times there is going to exist intimate material of you in some setting. For those victims of human trafficking, when they get pulled out and they're rescued from that system, they're still victims every time the material is transmitted or disclosed to anyone else. This would now make that an offense as well. And that's directly with conversations, an interesting conversation I had with the Attorney General's office.
Thank you, Senator England. Thank you, Mr. President.
Thank you, Senator Horn. Senator Turner, for what purpose you seek recognition?
Question, Mr. President.
Please proceed. Senator. Thank you. Please proceed.
Thank you, Mr. President. Thank you, Senator, for yielding. Do you believe that there can be, well, let me go back. When we discussed this bill in committee, one of the questions I raised was the use of the word disclosed. Mm-hmm. And it was made clear, as I understood it, that if this material was disclosed to one person, that was the equivalent of if it was disclosed on the internet or by any other means. Is that correct?
That's correct. That there's an intent to disclose to another person, and I would liken that to just an example that I'm not sure if we raised in committee, but if you have shared intimate materials with your significant other, and you are threatened with the fact that that offender is going to share that with your grandmother, that would be a disclosure, and that would be a violation under this act, and the person could be prosecuted. I guess I want to preface my question. I'm not trying to defeat the bill, but do you agree that there can be different levels of disclosure of intimate material? One person versus on the internet where 100 people can see it. Yes, Senator Turner Ford, I absolutely agree with that, and I would say that I have faith in our prosecutors around the state to make sure that they use this correctly. And currently, they don't even have the option to prosecute this type of behavior, and we're allowing them the opportunity to do so. If we do this, and if for some reason we find this is being abused in any way, we can always come back. But this is bringing us in line. We will again be the 47th state, leaving just 3 out there that aren't allowing victims this remedy.
Thank you, Mr. President. I'd like to be recognized to make an amendment at the proper time.
Thank you. We're on any other questions or comments? We're on the committee substitute. So, Senator, will make your motion on adoption of the committee substitute.
I would like to move that we adopt the committee substitute, Mr. President.
All those in favor signify by saying aye.
Aye.
All opposed, no. The ayes have it. Senator Turnford, you're recognized for amendment. Do we have any other amendments?
Yes, sir.
It's up on the screen, Senator.
Thank you, Mr. President. I believe that there are different levels of disclosure of intimate material, and I think that in giving prosecutors the tool that they would need to hold someone guilty or responsible for this type of conduct, I believe that we need to allow them the opportunity to decide if that first offense, whether it is disclosed one person or 100 people, if that should be charged as a felony. And in order to accomplish that and to continue to work on the bill, I'm offering a reverse repealer. I'll yield for questions.
Any questions? Questions on the amendment? Senator England, you're recognized to speak on the amendment.
Thank you, Senator Turner. I would ask the body to vote no on the amendment for the reason that we did pass this bill as a body in 2019. I do appreciate Senator Turner's questions and her concerns on this bill. But I do hope that we can send this bill over to the House with their having the ability to pass this, and that we can get something done on this. I would again point out that a first offense, should a prosecutor choose to bring charges under this act and under this new offense, the first offense would be a misdemeanor, and the second offense would be a felony. So we do have a very milder, or a much milder situation after one offense. So I think that may, at least in my opinion, I know it may not for Senator Turner, that to me addresses the concern of what levels does this get to. And again, if it's used for profit, if someone discloses this material not only for the purpose of embarrassment or to cause stress for another individual, but also to profit and put money in their pocket, it would automatically become a felony. So there is already a graduated system there. So I appreciate Senator Turner's amendment and look forward to this bill hopefully passing regardless, but I would ask that we can send this over without a reverse repealer.
Senator Turner Ford, we are recognized to close.
Thank you, Mr. President, and I understand that the senator would like a clean bill, but we also want to make sure that we have a bill that is effective, and one disclosure can be enough to damage a person's reputation. It does not have to be a matter of profit, and we need to send a clear message when this bill is passed out of this Capitol that this type of behavior will not be tolerated, and I move for adoption of the amendment.
Thank you, Senator. Motion is to adopt the amendment. All those in favor signify by saying aye. Aye. All opposed, no? No. Let's try again real quick. All those in favor signify by saying aye. Aye. All opposed, no. No.
Division.
Please return to your desk. Senator Frazier, would you ask Senator Norwood to come around? And Senator Witherspoon, I believe, is up there. She's here. Okay, we ready? All in favor, stand. All in favor, please stand.
One back here, too. Black.
So it's 15.
Yeah, that's what I got.
16. Okay. Opposed? No. Please rise. By a vote of 16 to 25, the amendment fails. Moving back, we're now on the committee substitute. Senator, you're recognized.
Thank you, Mr. President.
We adopted a committee substitute, I'm sorry. So we're back on the bill. I apologize. We're ready for a motion.
Yes, thank you, Mr. President. I move that we adopt this measure by use of the morning roll call.
Senator, move adoption by use of the morning roll call. Does anyone object to the procedure? Anyone wish to be recorded as voting no? Present. Present. Turner Ford. Anyone else? Anyone else? Seeing none, the bill passes by use of the morning roll call with one present. Mr. Clerk. Senator Fillingame, you're recognized. We're back on 71.
Thank you, Mr. President. I'd like to get item number 71 called up and have the title read.
Mr. Clerk, please read the title.
Senate Bill number 2223, arrest warrants, authorize issuance for sex offenses against children upon oral testimony.
I make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye.
Aye.
All opposed, no. The ayes have it. Please proceed, Senator.
Thank you, Mr. President. I move that we adopt the committee substitute in lieu of the original bill and ask to recognize Senator Hill to explain the committee sub.
Senator Hill's recognized for the committee substitute.
Thank you, Mr. President. Yesterday, you got on your desk a page from the Attorney General's office. It looks like this. It has a little red seal at the top. This is a bill that we passed through Judd B. that was asked for by the Attorney General's office that would authorize issuance of arrest warrants for sex offenses against children upon oral testimony. And what this bill does is it authorizes search warrants to be issued upon oral testimony provided telephonically to a judge for investigations of sex offenses involving computer crimes against children. So the judge would be able to get a telephone call from the officer, from the investigator, rather than having to be right in front of him. So it's just basically using technology to speed up the process when it comes to sex crimes involving computers against children. It also details a procedure for requesting a warrant telephonically from a judge. He would have to record the teleconference or make use stenography or longhand record of the call. So, and the judge is also to place the parties providing oral testimony under oath. So it's doing the exact same thing that you would do if you were face-to-face, rather being able to use telephones and longhand dictation or a teleconference to get it done. The person requesting the warrant shall read from a duplicate original warrant to the judge, who shall have or create a copy of the duplicate original warrant that will be considered the original warrant. If the judge is satisfied that there are sufficient grounds for the warrant to be issued, the judge shall direct the person requesting the warrant to sign the judge's name on the duplicate original warrant, and the judge shall simultaneously sign his or her name on the original warrant. The contents of a warrant upon oral testimony shall be the same as a warrant upon affidavit. The person who executes the warrant shall enter the exact time of execution in the face of the duplicate original warrant. So it's the same procedures. If you were face-to-face, it's just allowing you to speed this up through the technology and improvements that we've made throughout numerous years. And some courts already are using this. Justice courts use it, so this would just extend it to other courts, to circuits. It also, currently a circuit, county, or chancery court in a county that uses Mississippi's electronic court system can electronically sign orders, including domestic abuse protection orders. Last year, the legislature passed HB 25, which requires all circuit, county, and chancery courts to utilize that by mid-2021. However, municipal and justice courts, both of which are authorized to enter domestic abuse protection orders, they don't use it, and the law is unclear as to whether they have the authority to electronically sign these orders. So they want to give them statutory authorization to make sure that they know that they can do this in a domestic abuse protection order that seeks emergency relief. So that's what the bill does. Be glad to entertain questions.
Any questions on the bill?
If I don't have any questions, I'd ask for passage on the morning roll call.
We're still on the substitute, Senator.
I'm sorry, adopt the committee substitute in lieu of the original bill.
Any questions? Any questions? Seeing none,
Not, I'd like to motion to adopt the bill on the passage of morning roll call.
we haven't got the committee sub. Hold on, Senator. You're one ahead of us. All in favor of the committee substitute, please signify by saying aye. All opposed, no. The ayes have it. Senator, we're ready now on your motion.
I'm sorry, back on the original bill, motion for passage on the morning roll call.
Senator moves from passage on the morning roll call. Anyone object to the procedure? Anyone wish to be recorded as voting no?
That's right.
Any present? Seeing none, the bill passed by use of the morning roll call. Senator Fillingham, you're recognized.
Thank you, Mr. President. There it is. So I'd like to go to item number 72, call it up and have the title read, please.
Mr. Clerk, please read the title.
Senate Bill number 2282, Youth Detention, raise minimum age for youth commitment to state training school and secure detention.
Make the usual motion.
Senator makes the usual motion. All in favor, please signify by saying aye.
Aye.
All opposed, no. The ayes have it. Please proceed, Senator Fillingham.
Thank you, Mr. President. If you'll recognize Senator England to explain this bill, please.
Senator England, you're recognized on the bill.
Thank you, Mr. President. Thank you, Chairman Fillingham. Colleagues, what Senate Bill 2282 does, very simply, it raises the minimum age for youth commitment to a detention type center, state training school, and secure detention. It raises the age from 10 to 12. Just a few stats before I ask to take any questions or to vote on this. There's research that was done in Texas that found that it costs 3.5 times more to detain a youth per day than it does to provide non-secure alternative or electronic monitoring. I would also point out that studies show that children in the age range of 10 to 11 actually have the lowest crime rate of anyone in the country, and the possibility of someone returning back to prison after being put into a detention center at such a young age is so much higher. This just raises that age level from 10 to 12. If there are no questions, I ask that we adopt this measure by use of the morning roll call.
Questions? Seeing none, Senator Turner Ford.
Thank you, Mr. President. Has there been any conferencing or conferring with the youth court judges as it relates to this?
Senator Turner, I did actually talk with two youth court judges on the coast that I respect very much, Sharon Segalis and Trent Farr. I talked with both of them late last session. I say late last session, we all know how last session went. I'm not sure exactly when it was in the year. But they told me that they do not use this measure for anyone of that age. I haven't talked with any others, but I do believe that this, just from 10 to 12, there will probably be some children that do not get caught up in this, but there are other measures that can be used that youth court judges can use, such as mentoring or different training or oversight of these individuals without, for lack of a better word, locking up these children for their actions.
So there would be no option for detention between 10 and 12?
Yes, well, at the age of 12, they would be eligible to use detention. But if you're 10 or 11, then you would not. Again, it just raises the age currently says 10 in the statute that we have now currently. This raises it to the age of 12.
Thank you.
You're welcome.
Thank you, Senator. Any other questions? Okay, Senator, we're ready for your motion.
Yes, my motion is that we adopt this measure by use of the morning roll call.
Morning roll call has been requested. Anyone object to the procedure? Wish to record as voted no. No. Present? One present. Turner Ford. Any other present? Present. Seeing none, bill passes by use of morning roll call with one exception. Mr. Clerk, we're on Senator Fillingame. Back to you.
Thank you, Mr. President. I'd like to go to item number 73, call it up and have the title read.
Mr. Clerk, please read the title.
Senate Bill number 2573, Department of Public Safety implement uniform reporting standards for jail census data and create and maintain centralized database.
Make the usual motion.
Senator makes the usual motion. All those in favor signify by saying aye.
Aye.
All opposed, no. The ayes have it. Please proceed.
Thank you, Mr. President. I move that we go to the committee substitute in lieu of the original bill and ask that you recognize Senator Barnett to explain
Senator
the committee's
Barnett, you are recognized, and the President Pro Tem will be taking over for a minute.
Thank you, Mr. President. Members of this body, I'm sure we've heard this term several times here today, but this is a simple bill. It was asked of me by judges, sheriffs, and others in the law enforcement community to craft a piece of legislation that will require all agencies to be able to report all of the jail census data into one place so that it could be shared amongst the agencies so that things could be a little bit more transparent amongst our agencies. And that's basically what this bill does, and I'm open to any questions.
Are there any questions? Well, did we make a usual motion? I just got up here. We did? Okay. Have we adopted the committee substitute?
Yeah.
Why don't we go ahead and adopt the committee substitute and then take questions, if that's all right. Would you make that motion to adopt the committee substitute in lieu of the original bill?
Senator.
He's already done that? Yes. Okay, well, we haven't voted on it. Okay, well, let's do that. Let's adopt the committee substitute in lieu of the original bill. All in favor say aye. All opposed, no. The ayes have it, so we're on the committee sub. Now, do we have any questions on the committee substitute?
If there's.
So you're recognized. Are you finished? I'm sorry, I just got up here. I'm not sure what all has happened before. Okay.
Yeah, move to adoption by morning or use of the morning roll call.
Senator requests use of morning roll call for final passage. Anyone object to this procedure? Anyone wish to be recorded as voting no? Senator Barrett? Anyone else wish to be recorded as voting no? Seeing none, please record all present by use of morning roll call as voting aye. Okay. We're on 74. Senate Bill number 2283.
I'd like to go to that item, Mr. President, calling up and have the title read.
Please read the title.
Senate Bill number 2283, Freedom of Roadway Act enact.
I make the usual motion.
Senator Philgame makes the usual motion. All in favor say aye.
Aye.
All opposed no. The ayes have it. Senator Philgame.
I move that we adopt the committee substitute in lieu of the original bill, Mr. President.
Senator requests to use that we adopt the committee substitute in lieu of the original bill. All in favor say aye.
Aye.
All opposed no. The committee substitute is adopted. Senator Philgame.
If you'll recognize Senator McMahon to explain the bill, please, sir.
Senator McMahon, you're recognized.
Mr. President, thank you. This is a bipartisan bill. It just takes existing law for anyone that would block roadways or any other public passages and would enhance the crime and would enhance the fees from currently the fee is $500 and it would change the fees to $1,500 and the second offense would be $2,500. Like I said, it just takes existing law, guarantees passage of the roadways here in Mississippi. If there aren't any questions, move for passage of the morning roll call.
I'm sorry. Where were you?
My motion is to move for passage on the morning roll call.
Senator requests use the morning roll call for final passage. Anyone object to this procedure? Any questions? Anyone wish to be recorded as voting no? Seeing Senator Bryan, Senator Blunt, Senator Simmons, Senator Frazier, Senator Jordan. Who is it? Senator Jordan. Senator Thomas. We already said Simmons, have we not? Senator Derek Simmons, sorry. Robert Jackson, Senator Thomas, Senator Witherspoon, Senator Norwood, Senator Horn, Senator Butler. Anyone else? Would you read those off, please? Please read off the ones that recorded and voted no. Anyone else? If I missed anyone, punch your button. I'll see you on the.
Voting no or nay. Bryan, Blunt, Simmons of the 12th, Frazier, Jordan, Butler, Thomas, Norwood, Horn, Witherspoon, and Jackson of the 11th.
I don't like that.
That's what we've been doing all day.
I know it, but that ain't the way we used to do it, but okay. 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 All right. Let's see. Seeing the, let's see. Please record all present by use of morning roll call except those that have voted no. All right, so we'll go to item 75. Senator Jordan. Yeah, we're going to adopt the committee stuff anyway.
Thank you, Mr. President. We go to item 75 and ask that title be read.
Please read the title.
Senate Bill number 2119, pseudoephedrine and ephedrine, authorized sales and purchase of certain products containing without a prescription.
Senator Jordan.
I make the usual motion.
Senator Jordan makes the usual motion. All in favor say aye. All opposed no. The ayes have it. Senator Jordan.
I move that we adopt a substitute in lieu of the original bill.
Okay, well, let's do that and then explain it.
Yes, sir.
Either way you want to do it, Senator.
All right.
You want to adopt it first?
No, I'll have somebody to explain it. I'd like to allow Senator Philgame to explain the bill.
And then we'll adopt it.
All right.
If that's okay, Senator Philgame.
Thank you, Mr. Chairman. Thank you, Mr. President. So Senate Bill 2119 is basically the Sudafed bill. Many of you who've been here for a while will remember any number of years ago, there was a outbreak of meth labs, not only in Mississippi, but around the country. And in response to that, we passed legislation, as did many states, that required a prescription in order to purchase pseudoephedrine or ephedrine products such as Sudafed, many other products you'll probably be familiar with, things like Claritin D, Aleve D, Primatene, Zyrtec D. Many of these products, it's not just Sudafed, but it has that product, the pseudoephedrine or ephedrine in it. We required those products to be placed behind a counter at a pharmacy and that you receive a prescription for said product before you would be able to purchase that. And it did have a good effect. The number of meth labs across the state and across the country went down. Unfortunately now, as with many things, technology has sort of gotten past where we were, so there are now better products and ingredients that the meth makers use to produce crystal meth, and unfortunately there's an influx of crystal meth being produced in Mexico and being sent to the area. So unfortunately, the situation you find ourselves in now, almost all states have now gone away from the prescription requirement that we still currently have, is that the law-abiding citizens are really the only ones that are being negatively impacted. So if you and I have allergy problems or, stuffy-headed problems, whatever, and you want to get a product like Claritin D or Sudafed for relief from your congestion, you have to go and pay a doctor or nurse practitioner, some person in the medical field to see you, to give you a prescription, then carry that prescription to the pharmacy and get your relief product. And then there's still plenty of meth to be had, unfortunately, around the state. So what this bill seeks to do is it seeks to remove the prescription requirement that was put in place years ago. It will still remain behind the counter at a pharmacy, so you will still have to go up and ask for the specific product from the pharmacist, and there will be a record kept. And that will be done through a system called NPLEX, which is software that the pharmacies have, because there is a limit to how much you can get, because they still want to monitor, because you can still use it to make meth. It's just most people don't anymore because there are better products and cheaper meth available from Mexico. But the limit would be, and this is on the committee substitute lines 15, 16, 17, is 3.6 grams per day or a total of 7.2 grams over a month's time. And the way the NPLEX system works is if you go down to the pharmacy on Main Street and buy 3.6 grams today, and then you go down to Jones Street Pharmacy and try to buy it again, they're not going to let you, because all these systems are interconnected and they know that Joey Fillingame purchased 3.6 grams of Sudafed at the pharmacy on Main Street, and so if I go to any other pharmacy, I'm not even in the state, but in the country, all these pharmacies are connected with the NPLEX system. You're going to be turned down until that amount runs out, and then you can purchase another amount up to 7.2 grams per month. And the equation of how do they get to this 3.6 grams, I think Senator Williams maybe had asked earlier in one of the committee meetings, and I've done a little more research than I had at that point. 3.6 grams equals the amount that an adult would need for 15 days worth of product, and 7.2 grams, of course, would be 30 days or a month's worth of the product. But they just don't make you go and buy it per day to take it every day. So you can buy up to 15 days worth, which is a 3.6 grams, or 7.2 grams for a whole month, but then you're limited and you can't buy any more until the following month. So that's how those quantities were arrived at. So I wanted to point that out since we've been asked earlier. There is a 2-year repealer on this because we had talked to the folks in our law enforcement community about doing this. We just didn't want to, surprise them with this. And for the most part, I know MBN I've spoken with and Commissioner Tyndall, I still want to say Senator or Judge Tyndall, but Commissioner Tyndall, we talked with him. They are okay with doing this, but they did want a 2-year repealer placed in the bill so that they can monitor the meth lab activity over the next 2 years, should this become law, to make sure there's not an increase again. And if so, then we'll be able to address that because of the repealer. Now, there is one amendment that I would need to make at the appropriate time, Mr. President, because also included in this bill, there was an attempt by some in the pharmacy group to add an additional product, which is a cough syrup with codeine onto the language of this bill to be monitored by the NPLEX system. And at that time, we had some conflicting information. Some people said that could be tracked through NPLEX. Others had suggested it could not be. So we went ahead and put it in the current committee substitute language. However, we've since found out and verified that it cannot be. The codeine medicine, cough syrup, cannot be added to the NPLEX system. It's specific to the pseudoephedrine and ephedrine products, and that is not one. So I've talked with the pharmacy folks and as well as the others who were interested in this bill, and they are all in agreement that that language needs to come out. So at the appropriate time, Mr. President, I do have a amendment to take out that.
Senator, before we do the amendment, let's adopt the committee sub. Do you move that we adopt the committee sub and include the original bill?
Yes, sir.
All in favor say aye.
Aye.
All opposed, no. The ayes have it. Committee sub's adopted. Now for the amendment, Senator Fillingham.
Do y'all need that? Okay. I think that amendment is on the screen. It amends a few words out of lines 35 and 36, which was the code section dealing with the cough syrup that we had also tried to include in this bill, which we have now since found out cannot be included. So that merely takes out the cough syrup addition to the bill that I would move adoption of the amendment to take that language out.
So move for the adoption of the amendment. Are there any questions? All in favor of the amendment say aye.
Aye.
All opposed, no. The amendment's adopted. Senator Fillingham.
Thank you, Mr. President. I'm happy to answer or attempt to answer any questions if there are any. If none, I move adoption by use of the morning roll call.
Are there any questions? Seeing none, Senator requests use of morning roll call for final passage. Does any senator object to this procedure? If not, then please record all. No, I did ask. Nobody said no. Does anyone wish to be recorded as voting no? I'm sorry. I thought I said that. I'm sorry. Okay. Senator Chisholm, Boyd, Sparks, Suber, Younger. That's it? Present for McMahon. Younger, I called your name. Present? Okay. Present instead of no for Younger, if you would. Okay. Senator Hill, did you wish to be voted as present?
I'd like to co-author unanimous consent when you get done counting.
Okay, thank you. We'll do that. I started to say Senator Jackson just for fun. Senator Carter, present. All right, please record. Oh, please read those off, if you would, Mr. Clerk. Oh, Senator McDaniel, did you wish to be voted as no or present?
No, sir. With consent, I would like to be added as a co-author to item number 75, Senate Bill 2119.
Okay, that's the one we're on. All right, hold on, we'll do that after we do the vote.
We've got 3 presents.
Read those off.
Voting no or nay, Boyd, Chisholm, Sparks, Suber, and Younger. Boyd, Chisholm, Sparks, and Suber. Voting present, McMahon, Carter, Younger.
Okay, anyone else? All right, then if you would, Mr. Clerk, please record all others present by use of morning roll calls voting aye. All right, now, Senator McDaniel wishes to be named as a co-author. All in favor, let's see, Senator Jackson, Senator Jordan, anyone else wish to co-author? Senator Hill, thank you. And Senator Sojourner, please name them. Well, will you read those off also as that wish to be co-author? Make sure we have everyone.
Yeah, Jordan wanted to be. You got Jordan, all right. Where are you?
Right here, Hill, McDaniel.
Okay. Voting or asking unanimous consent to be co-author, Hill, McDaniel, Jackson, Sampson Jackson, Jordan, Sojourner, and Robert Jackson.
Yeah, not Sampson. Not Sampson Jackson, if you would. Okay, thank you. I'm sorry, I just said Jackson. I should have said Robert. Okay. So, all right. So that'll take care of that bill. We've already voted on it, right? So, okay, we'll go to item 76, Senate Bill number 2795. Corrections, not going to, you pass and retain its place on the calendar. Item 77, Senate Bill 2603, Insurance, Senator Michelle.
Thank you, Mr. President. I'd like to go to item 77, Senate Bill 2603, and ask that the title be read.
Please read the title.
Senate Bill number 2603, salvage or abandoned vehicles, authorized disposition by auction firms on behalf of insurers.
Make the usual motion.
Senator Michelle makes the usual motion. All in favor say aye. All opposed say no. The ayes have it. Senator Michelle.
Thank you, Mr. President. This bill attempts to correct some difficulties that are experienced when an automobile has been declared in a total loss and the insurance company has paid the claim. On line 41 of the bill, you can see that when an insurance company makes a total loss settlement, the owner of the vehicle is obligated to notify the insurance company within 15 days to provide the insurance company the title of the policy. Unfortunately, in a total loss claim, oftentimes the owner does not send the title to the insurance company. I guess for several reasons. Maybe the title was burned up in the vehicle, or maybe the title was lost, but there's a lack of motivation from the owner of the vehicle to send the title because they've received their payment from the total loss. This bill will help an auction company or an automotive parts company get a salvage title so that they can liquidate the car, or a dismantling company can sell the parts. Upon notice from the insurance company, the auction company can notify the car owner and the lien holder that they have 30 days to pick up the vehicle. If the vehicle is not picked up, the auction firm or the car parts dismantler can get a salvage title from the Department of Revenue. So what you've got is typically a vehicle that's beyond repair, and we're trying to clear the title so that an auction house or a car parts dismantler can sell the vehicle and get what little money they can out of it. Be glad to yield any questions, Mr. President. I move.
Are there any questions? Seeing none, Senator Michelle. Oh, I'm sorry, we do have a couple questions. Thank you. Senator Younger, question? You yield to Senator Younger for a question. Senator,
yes, sir.
Senator
Friendly question, Mr. President. Thank you. Thank you, Mr. Chairman. Senator, we talked earlier about cars coming out of Louisiana if you buy them on Copar. Could you ask the legal staff over there if we did buy a car from Louisiana or anywhere, could we get a salvage title personally if the vehicle is not wrecked?
You want me to ask them at this point, or was that something you'd like me to work on for in the future?
Well, if we're buying on Copar and other people are buying on Copar,
right,
we should be able to get a salvage title whether that vehicle is wrecked in 4 or 5 different vehicles or if it's just one vehicle.
Well, I think that's a piece of legislation for another day. It would not be included in this legislation. I think you've got a great idea. It's just not going to be included under this bill.
Thank you.
All right, thank you, Senator.
Senator Moran, you have a question?
Yes, question, please.
You yield to Senator Moran.
Yes, sir.
Senator Moran.
This doesn't in any way include towing services, does it?
No.
Okay. And the reason being, I had a constituent that a car got stolen, and the young man, they figured out later, just parked it on an old road, and a towing service picked it up. Nobody seemed to know where it was. About 40 days later, he happened to find out where it was, and there was this huge towing fee. And luckily, being that it was already reported stolen, he was able to get out of having to pay that enormous storage fee. It wasn't his fault that the car was stolen. It was behind an enclosed fence that you couldn't see him. No one knew it was there. So I guess what I'm saying is, you said after 30 days you could get a title and sell it. Just want to make sure that this does not include towing service.
No, what we're trying to solve is a very minor problem because of the way the titles typically, I've spoken to chairman of the banking committee, if there's a lien on a car, on an automobile, if they've got a bank loan as an example, the insurance company is going to make that payment payable to the bank and the owner of the vehicle. If there's not a lien on the car, the insurance company will pay off the car owner. What we're finding, though, is there's problems of getting the title back from the car owner because they want to make that payment, and this is good. We want the insurance company to pay that claim quickly, but we also want them to get the title to where they can move the vehicle, because if it's stuck in a parts house, then it's kind of in no man's land. Okay. So this will allow them to get a salvage title to move the vehicle and complete the transaction.
All right, you know, because if we're talking about an older car that there is no lien on it, and it gets stolen, or a towing company picks it up, you know, because most times they have those enclosed fences. You can't see which vehicles are in there. And if it happens to be that you're 30, 40 days later before you figure out where your car is, I don't want it to be a situation where they could have sold it for a salvage title and you didn't even realize your car.
No, they'll know where the vehicle is on this one because they have to know where the vehicle is. They have to notify the owner.
Okay.
They have to give them that 30 days notice, the lien holder, and if there is a lien holder, certainly the owner, and they will know where the vehicle is because they've paid the claim off.
Thank you, sir.
Thank you. Mr. President, I move title sufficient. I move final passage by use of the morning roll call.
We have a couple more questions, Senator.
Thank you.
Senator McMahon, do you have a question?
I do.
You yield to Senator McMahon.
Yes.
Senator
Okay.
McMahon.
Senator Michelle, I appreciate what you're doing here. I've got a question. What if it's a situation where someone has like an antique car and it's wrecked and totaled, and then the insurance company wants the title, but I want to keep the car. I owned it outright. There's no lien against it. How can that be? Can that be worked out? Does that forego that? Is this a forced sale of my antique car?
The language is that the auction house, auto seller, will notify the owner of the vehicle, and they have up to 30 days to come get it. And 99.9% of the time, nobody wants a car that's not movable. It's probably more expensive to get the car back to their house, and then what do you do with it if it's already been totaled?
That's a great, thank you.
Yes.
That satisfies. Thank you, sir.
Thank you.
Senator Sparks, you have a question?
I do, Mr. President.
You yield to Senator Sparks for a question.
My good friend.
Thank you, Mr. Chairman. Believe it or not, I thought Senator McMahon and I were going to ask the same question. I was about to faint. But the question I have, which may be similar to what Senator McMahon was asking, is we're protecting the insurance company here. We're saying if the insurance company pays the value of the total loss, that if they don't receive the title typically from the owner, if there's no lien holder, so it would be in my personal possession, that they can go to the Department of Revenue and request a title to expedite. Is that correct?
This is the opportunity to complete the whole transaction, to get rid of the vehicle because of the lack of the title appearing to the insurance company.
Right. But in the reverse, if I do not have a lien holder, I own my car free and clear, and it's a total loss, and the insurance company pays me, and I want to retain the vehicle to repair or for parts, I want to give the individual the same right we're giving the insurance company, because the way the process works today is I have to take my title, send to the insurance company, even though they reduce my payment by the amount that I'm purchasing the wrecked car, and they have to get it titled in their name and then send me a title and a salvage title. So I would hope we would do the same thing for a vehicle that did not have a lien holder, that in a total loss, the insured chose to purchase the vehicle back. Does that make sense?
Yes, sir, that does. That would, in my opinion, the insured would have the opportunity to talk directly with their insurance provider. This is when the vehicle has gone to an auction house or a salvage parts place, and they're holding the vehicle, and their hands are tied because they don't have a salvage title, and they can't do anything with the vehicle, and it's sitting on their property. So it gives them the right to work towards getting that salvage title by giving the proper notice to the owner of the vehicle.
Okay, thank you. Thank you, Mr. Chairman.
Thank you.
Senator Sampson Jackson, do you have a question? No? All right. Seeing no other questions, the senator requests use of morning roll call for final passage. Anyone object to this procedure? Does anyone wish to be recorded as voting no? Seeing none, please record all present by use of the morning roll call as voting aye. Now we'll go to item 78.
I'd like to pass.
Senator Michelle.
Yeah, thank you, Mr. President. I'd like to pass item 78, pass item 79, and ask that they retain their place on the calendar and go to item 80. Senate Bill 25, and ask that the title be read. Senate Nomination 25, and ask that the title be read.
Thank you, Senator Michelle. We'll retain item 78, 26, 23, and 79, 26, 31 as placed on the calendar. Go to item number 80, Senate Nomination number 25, and ask the title be read.
Senate nomination number 25, Elizabeth Ashley Beth Harkins, Madison, Mississippi, Mississippi Workers' Compensation Commission, as a commissioner representing the employee interest, 6-year term effective immediately and ending December 31st, 2026.
Senator Michelle.
Thank you, Mr. President. This is a reappointment to
Do we make the usual?
Make the usual
We don't make
please.
you're right, we do not make the usual motion on appointments. Go ahead.
Okay, this is a reappointment, Mr. President, Ms. Beth Harkins to the Workers' Comp Commission. She served very well since 2015. Her background, the peer background report our insurance committee was provided is very good, and she's been an exemplary member of the Workers' Comp Commission, and I move that we do advise and consent by use of the morning roll call.
Okay, are there any questions? Senator requests use of morning roll call to advise and consent by use of morning roll call. Do we have a question? Senator, well, we do have a couple of questions. Senator Hobson, do you have a question? We have a couple more.
Thank you, Mr. President. Thank you, Mr. Chairman. Last name is Harkins, is that right?
That's right.
Any relation to our own Senator Josh Harkins playing hooky today?
Very well could be his younger sister, and in the committee, we gave him an opportunity to try to get back at her, and he said we want peace at Thanksgiving meals, so he chose to remain silent.
Does she look anything like Senator Harkins?
Much prettier.
Well, okay, that's a good thing, because I thought we might have to send it back to committee. Thank you, Senator.
Much prettier and as smart.
Hey, Senator McCon, where are you? I have a question. No, I don't see him. Where is he? He what? We'll move on. I guess he decided not to ask that question. Okay, so no other questions. Senators ask that we do advise consent by use of morning roll call. Anyone object to this procedure? Anyone wish to be recorded as voting no? Seeing none, please record all present by use of morning roll call as voting aye. Thank you, Senator. We'll go to item 80. Senator Michelle. Oh, that was 80. I'm sorry. 80. Thank you. I'm not all with it today. Item 81. We'll pass and retain item 81. Item 82. Oh, 81 or 82? 82. Senator Kaufman, Senate Bill number 2204, item number 82.
Yes, I'd like to bring up item number 82 and ask the title be read.
Please read the title.
Senate Bill number 2204, Revised LLC Act and Mississippi Registered Agents Act, require listing of registered agent's email address.
I make the usual motion.
Senator Kaufman makes the usual motion. All in favor say aye. All opposed, no. The aye has it. Senator Kaufman.
All right, this bill was requested by the Secretary of State's office. This update adds a requirement for the registered agent's email address to be included on all filings with the Secretary of State. This change would be phased in moving forward with new filings. Mailing notices would still be an option for those filing without an email address, and it also does not change any notice requirements under statute. It just allows for an easier, less costly communication. That's an explanation of the bill. If there's no questions, I ask passage by the morning roll call.
Are there any questions? Seeing no questions, Senator requests use of morning roll call for final passage. Any senator object to this procedure? Does anyone wish to be recorded as voting no? Seeing none, please record all present by use of the morning roll call as voting aye. Senator Kaufman.
I ask that we skip the next two and move to item number 85, Senate Bill 2628.
We'll pass and retain items 83, 84, Senate Bill 2626 and 2627. Go to item 85, Senate Bill number 2628. Senator Kaufman.
I ask that the title be read.
Please read the title.
Senate Bill number 2628, Credit Availability Act, extend repealer on.
Senator,
Make the usual motion.
Senator Kaufman makes usual motion. All in favor say aye. All opposed, no. The aye has it. Senator Kaufman.
All right, what this bill does is it just extends the repealer on the Credit Availability Act that we passed back in 2016. We also extended a repealer in 2018. We make no changes to the heart of the bill. We're just going to extend the repealer for another 4 years. That's the explanation of the bill. If there's no questions, I ask passage by morning roll call.
Let's see, I think we have a question. Senator Blunt, do you have a question?
Yes, Mr. President.
You yield to Senator Blunt.
I do.
Senator Blunt, you're
Thank you, Mr. President. Thank you, Mr. Chairman. This is a bill that deals with check cashers and cash for title places and all those industries.
Yes, that's correct.
And we're not making any changes to existing law under the bill?
No, no changes whatsoever.
Should we?
I don't believe we should. I think everything's been going fine like it has been. I think we just keep it going like it is.
So you feel like the current laws we have in place regarding, check cashing places and cash for title places provide sufficient protections to the consumers and people of the state?
I absolutely do. Yes.
All right. Thank you.
Okay, any further questions? Seeing none, Senator requests use morning roll call for final passage. Any senator object to this procedure? Does any senator wish to be recorded as voting no? Seeing none, seeing one, Senator Simmons? Yes. Anyone else wish to be recorded as voting no? Record Senator Simmons as recording no. Who's up there? Senator Norwood and Senator Frazier is voting no. Okay, so, other than those 3 or 4 voting no, you want to read those off, just to make sure we have everyone?
Voting no or nay, Simmons of the 12th, Frazier, and Norwood.
Okay, seeing no others, please record all others present by use of morning roll call as voting aye. Bill is passed. All right, now, item 86, universities and colleges, pass and retain. Judd A, number 87, Senate Bill number 2086. Senator Wiggins?
Thank you, Mr. President. I go to items 87 and 88 and 89, ask that they remain on the calendar in their place, and go to item number 90, call that up and ask the title be read.
So we'll change the place on items 87, 88, 89, go to item number 90, and please read the title.
Senate Bill number 2483, electric bicycles, classifies bicycles and not as motor vehicles and regulate.
Senator
Make the usual motion.
Senator Wiggins makes the usual motion. All in favor say aye.
Aye.
All opposed, no. The ayes have it. Senator Wiggins.
Thank you. This is a bill filed by Senator Whaley, Chairman Whaley. It's, in short, it's dealing with electric bicycles, those ones that look like bicycles, have a little motor on them. Across the country, the laws are confusing as to whether they're bikes or motorbikes. And what this does is ensures that if there's any regulation, that they're regulated as bikes, and the local governments are allowed to make those decisions. And let's see, also that the bicycles are there to allow to be in different parks and go towards tourism. And it also is better for the environment to do that. So in short, to allow or to preempt any negative regulation so that they can continue to operate as bikes. Our neighboring state, Alabama, actually has more stringent regulations, but many of the states across the country are going to this. So with that, I'd be happy to answer any questions.
Are there any questions?
Move passage on the morning roll call.
Senator requests use of morning roll call for final passage. Any senator object to this procedure? Anyone wish to be recorded as voting no? Seeing none, please record all present by use of the morning roll call as voting aye. Senator Wiggins, on 91, you're going to take it up. Let's stop.
No, retain on the calendar.
Well, then, at that point, I would like to ask Senator Blackwell, unless you have another Judd A that you...
number 91 retain its place on the calendar.
We retain item 91 on this placed on the calendar. Hold on, please. Around 90. Do what? So 92, does he want to bring? Senator Wiggins, we're going to work a little bit longer. Do you want to bring up 92 or do you want to retain its place on the calendar? Oh, I'm sorry, that's labor first, isn't it? So we'd like to pass and retain? And then we go to item, we'll pass retain item 92, and then go to item number 93, Senate Bill number 2827, Senator Polk.
Mr. President, I ask that we skip number 93 and let it hold its place on the calendar, move to item number 94 and have the title read.
Okay, thank you. We'll pass retain item 93, 2827, go to item 94, Senate Bill 277. Please read the title.
Senate Bill number 2077, Central Market Board, abolish and transfer functions to the Department of Agriculture and Commerce.
I'll make your motion.
Senator makes use of motion. All in favor say aye. All opposed no. The ayes have it. Senator Polk.
Thank you, Mr. President. I'd like to recognize Senator Younger to explain the bill.
Senator Younger, you're recognized.
Thank you, Mr. President. Thank you, Mr. Chairman. What this does is it's the old Central Market Board. It was created in the 40s. It's outdated. It's dead. It was a wholesale market operation for farm products. DFA has taken it over. The property is on Woodrow Wilson, where the operation was located. The bill would abolish the old Central Market Boards, move this to the Department of Ag so that it can be properly managed right. The farmers market on High Street is where it would be located, of course. It will include running restaurants, market sales, as well as possibly wholesales. The Central Market Board, they did not allow retails, but this will allow retail sales. If there are no questions, I'd like to make use of the morning roll call.
Are there any questions? The Senator, I have a question. Seeing none, Senator requests use of morning roll call for final passage. Anyone object to this procedure? Anyone wish to be recorded as voting no? Seeing none, please record all present by use of the morning roll call as voting aye. Senator Polk.
Thank you, Mr. President. I'd like to call up item number 95. Ask the title be read.
Please read the title.
Senate Bill number 2098, State Board of Funeral Service, extend repeal or on.
Make the usual motion.
Senator Polk makes the usual motion. All in favor say aye. All opposed no. The ayes have it. Senator Polk.
I'd like to be recognized to explain the bill.
You're recognized.
Thank you, Mr. President. This is a simple repealer bill for the State Board of Funeral Service. It extends the repealer to July 1st of 2025. If there are no questions, use the morning roll call for final passage.
Are there any questions? Senator requests use the morning roll call for final passage. Any senator object to this procedure? Does anyone wish to be recorded as voting no? Seeing none, please record all present by use of the morning roll call as voting aye. Senator Polk.
Thank you, Mr. President. I'd like to skip items 96 through 100, and as they retain their place on the calendar, and then go to item 101 and ask that the title be read.
Pass retain items. The motion the request is that we go, retain 96 through 100 and go to 101. Is that correct, Senator Polk? Please read the title of 101.
Senate Bill number 2189, counties and municipalities authorized to offer Medicare-eligible employees supplemental compensation if employees secure Medicare.
Mr. President, make the usual motion.
Senator Polk makes the usual motion. All in favor say aye. All opposed no. The ayes have it. Senator Polk.
Thank you, Mr. President. I'd like to recognize Senator Hill to explain the bill.
Senator Hill, you're recognized.
I can go ahead and start. Basically, this is a bill that's requested by the counties, the Board of Supervisors Association. And what they would like to be able to do is, if a person is Medicare eligible, old enough to go on Medicare, if they choose to go on Medicare during annual enrollment and they have been on the county insurance, the county would like to be able to give them a supplement to facilitate their Medicare gap coverage. So they've done a financial analysis of how much they're paying on insurance versus how much they would be giving as a supplement for Medicare, and they've determined it will save a good bit of money. I have seen the numbers that they've compiled for us, and the bill denotes that they could not spend any more money than they are currently on the insurance policy for that employee, and that they would have to show on an annual basis that either Part D or whatever coverage that they're paying for Medigap. And that's all it does. It just doesn't force anybody to do anything. It just gives them the opportunity that if somebody wants to go on Medicare when they get that age, that they would provide them some funds that they were otherwise providing for insurance for a Medicare supplement.
Okay, are there any questions? Say no questions, you make a motion.
Senator McClendon.
I would like to offer an amendment on the very last line, amend on line 83, just to clarify that they have to show the coverage on an annual basis, that they're using the funds for the purchase of Medicare supplement on an annual basis.
Okay, first we have a question, then we'll do the amendment, if that's all right. Senator McClendon, you have a question?
Thank you, Mr. Pro Tem.
You yield, Senator McClendon?
Yes, of course.
Senator McClendon.
Thank you, Senator Hill. Medicare supplement policies have different price ranges. How are we going to determine which one, or can they go after the Cadillac policy, or will they be able to go after a Buick policy?
The counties would be able to determine how much they would pay as long as it was not over what they were paying for insurance payment. But looking at the average cost of Medicaid supplements out there, even on the high end, they're going to save a lot of money.
Thank you, ma'am.
Are there any further questions? If not, Senator Seymour, you have a question?
Question, Mr. President.
You yield, Senator Seymour.
Of course.
Senator Seymour.
Senator, will this affect, say, elected local officials, supervisors that are on Medicare, they get elected? Will they have some kind of benefit out of that?
Anybody that's on county or city insurance, anybody that's, but this is not city, this is a county, but anybody that's on the county payroll that has insurance, that's provided insurance now, doesn't put anybody on that's not already on. Anybody that's Medicare eligible, doesn't matter who they are, if they're on county insurance, this would allow the counties to give them a supplement for Medicare in lieu of what they're paying for their regular insurance if they choose to take Medicare at the Medicare age.
Thank you.
All right, seeing no, wait a minute. Senator Blunt, do you have a question? He passed. Okay, so seeing no further question, you have the amendment?
Yes.
If you'll offer the amendment, please.
They have the amendment on the screen. And the amendment would read, just to clarify, because we want to make sure that if they're getting that money, that they're purchasing that Medicare coverage. Receipt of purchase for the Medicare coverage shall be provided on an annual basis to the employer. And that's the national language.
You move for adoption of the amendment?
Move for adoption of the amendment.
All in favor of adoption of the amendment? I'm sorry.
The question.
Oh, you have a question? I'm sorry, Senator Turner Ford? I'm sorry, thank you.
Thank you, Mr.
You yield,
President.
Senator Turner Ford, for a question.
Of course.
My only question is, who's going to contract to pay the insurance?
They're going to give the employee a supplement. And it's up to the county. It'll be up to the county. You know, if they decide that whomever is taking Medicare, that this is a supplement they're going to have, and they make everybody have the same one, or if they can do it individually, that's up to them. It's not going to be a whole lot of people. There's not that many people that work for the counties that are at that age.
Right, and I'm familiar with the issue. I just want to make sure I understand who is contracting to get the supplement. Is it the employee, or is it the county?
It's the employee. The employee. They would show proof of that coverage during annual enrollment each year to be able to get that supplement. to get the funds to pay on that supplement.
And I'm just asking, has anyone checked with the state auditor's office on this?
I assume that there's no problem with it. This has been vetted, nationally through the association, but if the auditor has any problem with it, he has not called me.
Thank you.
Certainly don't want to get in trouble with Shad.
All right, seeing no further questions, the senators move for adoption of the amendment. All in favor say aye. All opposed, no. The ayes have it. Senator Hill,
Back on the bill, I move for
Yes.
passage on the morning roll call.
Senator requests use the morning roll call for final passage. Any senator object to this procedure? Does anyone wish to be recorded as voting no? Seeing none, please record all present by use of the morning roll call as voting aye. That bill is passed. And let's do one more, and I'm about to lose my voice.
I'm going to ask to skip 102 and let it retain its place.
All right, let's do that then. 102 and retain its place on the calendar. Senator Blackwell for a motion.
Thank you, Mr. President. I move to the Senate stand in recess until 5 p.m. today, which time the Journal will show we're adjourned until 9 a.m. tomorrow morning.
Senator Blackwell moves that we stand in recess till 5 p.m. this afternoon, at which time the Senate Journal Reflector will stand adjourned till 9 a.m. tomorrow morning. All in favor say aye. All opposed, no. The ayes have it. Senate stand in recess. Oh, I'm sorry. We had an announcement before we leave. We've done that, but if anyone wants to make an announcement, that's my bad. Does anyone wish to make an announcement really quick, even though we've adjourned? While we're still here, Senator Hobson, you had an announcement. Even though we've adjourned, you can still make the announcement.
Are we back on where we can make
Well, we're going to do it today.
I've just, on behalf of Senator Branding, she wanted to be added as a co-author to a few bills, but I can do those in the morning.
Okay, yes, if it's
Thank
that
you.
type of announcement, please do. Senator Derek Simmons, no announcement. Okay, thank you. All right, so, again, stand in recess till 5 p.m., at which time Senate Journal Reflects stand adjourned till 9 a.m. tomorrow morning. And Senate stand in recess.